Last week, during almost 4 hours of testimony, Wilson-Raybould made those allegations, and in detail. Now, Gerald Butts will give his side of the story, and that's what we're awaiting at this moment. Lots ahead in the next few hours, and here to watch along with us, CBC Polls analyst Eric Grenier, senior reporter Evan Dyer, and in Toronto, iPolitics reporter Marika Walsh. Hi to all of you. Nice to see you. So apologies in advance if I have to cut you off to get into the room there, but we are awaiting Mr. Butts' testimony. Of course, lots of anticipation, Eric. Mr. Butts actually resigned in the middle of all of this, insisting that he and no one in his office did anything wrong. But certainly that was one of the big events as this controversy unfolded.
And it keeps unfolding. Every week there's a new major touchstone of where things are turning. And I think a lot of people will be watching to see where Butts will go with this, because right now the Liberals are in some trouble. The Prime Minister, his own ratings have been sinking.
And there he is. There he is right now. There's Mr. Butts taking his seat.
He's in the room or
No,
something.
and they need him to have a performance that will.
They backdoored.
So essentially, just for people who are watching, what we'll see right now is there's a few moments before the testimony, before Mr. Butts' opening statement is delivered and questions begin, in which he talks to MPs who are various MPs from all the parties who are there. You saw Murray Rankin, one of the NDP MPs, who's on the committee, going over to shake his hand. Evan, what are you watching for?
I guess the tone would be the first thing, the first indication, and we should get that right away. You know, the information will come out over the course of a couple of hours, but right away we're going to see just how angry he is, just how much he's restraining himself, because I've always had a small doubt in the back of my mind that perhaps there is a difference of opinion between him and other people in the PMO about how to respond to this, and that might lie behind his resignation. You know, would he, for example, be more in favor of coming out guns blazing, while the PMO perhaps is saying, no, that would hurt us more? Might that explain why he resigned, and resigned saying, I've done nothing wrong? There's always been that possibility. I don't think it's likely, but it's possible.
And Marika, a couple things could temper that at this point, right? You've got Jane Philpott's resignation on Monday, I think it was, and as well the kind of testimony that we heard from Jody Wilson-Raybould last week. How might that impact the way in which Mr. Butts' testimony is delivered today?
I think Philpott's resignation tempers it a lot. I mean, we saw that from the PM when he was in Toronto Monday evening, that he already was saying he's taking this seriously, and he knows that more questions need to be answered. So I think that Evan's right, that we will see very quickly what the tone is, what the strategy is. I think it's also really important to note that it's not just the public and journalists watching this, it's also Liberal MPs who also don't have a ton of information yet on what went on. You know, we heard from some MPs earlier this week that they will be watching this testimony and trying to make up their own minds about what exactly happened.
Everyone? Okay, we're going to go right into the committee now. That's Anthony Housefather, the chair of the committee. Let's listen in to Gerald Butts'
the Shawcross Doctrine, and the discussions between the Office of the Attorney General and government colleagues. Today, we're joined by the Prime Minister's former Principal Secretary, Mr. Gerald Butts. Mr. Butts, it's a pleasure to have you at committee. Thank you very much for coming to share your perspectives on the matter that we're studying.
Thank you. Point of order, Mr.
Point of
Chair.
order, Mr.
Yeah.
Cooper.
Thank you, Mr. Chair. Before we begin, given the severity of the claims that have been leveled against Mr. Butts by the former Attorney General, and given that this matter has been referred to the RCMP, or a request has been made for the RCMP to investigate, I believe that it is appropriate in the circumstances that Mr. Butts be sworn in pursuant to Section 10 sub 3 of the Parliament of Canada Act, so that he can answer questions under oath, and that if he fails to tell this committee the truth and provide the answers that Canadians deserve, that he would not only be liable to being found in contempt of Parliament, but that he would also be liable for criminal perjury charges. Now, I recognize that this is really in the hands of the Liberal majority on the committee, and I would implore my colleagues opposite to support this motion, do the right thing, and if Mr. Butts has really nothing to hide, then I think he'd be quite open to taking the oath.
So, Mr. Cooper, as you know, you can't make a motion on a point of order. Given the importance of this, I'll allow, in any case, to have a motion put forward for Mr. Butts to be sworn in. I will point out what the clerk has told us at previous meetings when this issue has arisen, that nobody has been sworn in at this committee in at least 25 years, that somebody who is a witness, no matter who they are, is bound to tell the truth at committee. They have to. They can otherwise be found in contempt of Parliament. As Mr. Cooper pointed out, the distinction being that if Parliament is prepared to waive parliamentary privilege, which it has not done since Confederation, then a witness could potentially be liable for contempt. So since Mr. Cooper has previously made this motion, and I know we all want to get to the witness's testimony, may I suggest we just move to a vote on the motion, Mr. Cooper?
Yes, Mr. Chair.
Perfect. So would you like a recorded vote, Mr. Barrett? Okay, so Mr. Clerk, will you do a recorded vote, please? And this is on Mr. Cooper's motion to swear the witness in.
D'accord. Monsieur Boissonneau.
No.
Mr. Essassi.
No.
Mr. Fraser.
No.
Ms. Khalid.
No.
Mr. McKinnon.
No.
Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Ms. Raitt.
Yes.
Mr. Rankin.
Yes.
Yeas pour 4, 4, and nays contre 5, 5.
Merci, Monsieur de Creffier, dont le
Thank you, Clerk. This motion was defeated.
Yes, in a similar vein, I just had a couple of preliminaries. I think you've done this in other contexts, but I'd like to ask if you would remind all members the need to make sure the questions are relevant to the mandate that you've set out. That's number one. Number two, if the witness has a statement, a written statement like Ms. Wilson-Raybould did, I'd ask that it be distributed so we could study it. Thirdly, I'd ask that you allow this witness the same courtesy that you allowed Ms. Wilson-Raybould, namely to stay a little longer if there's a need to do so.
Thank you, Mr. Rankin. Yes, so number one, the witness has kindly provided a written statement. It's being copied now, and it will be, I believe copies are now available in both English and French. It will be distributed to the committee members and the other members at the table. With respect to the second question, my suggestion is I think we have a time within the scope of the 2 hours to go at least 3 rounds of questions. So we will at least do that, and then we'll see where we are. And I will also, in the third round, I'll ask the committee if they're willing to have Ms. May and Mr. Weir and people from other parties get 3 minutes, as I have previously done. With respect to the third, I will deal with questions in the line of questions when we hear the witness's statement, but I'll remind everybody, of course, what you have suggested, Mr. Rankin. Thank you very much.
Point of order, Mr. Chair. While I recognize that Liberal members have voted against my motion to swear Mr. Butts in, I see no reason why he might not voluntarily offer to be sworn in.
Thank you, Mr. Cooper. I don't know that that's a point of order. So we're going to need, Mr. Cooper.
Perhaps he'd be given point of order, Mr. Chair. Perhaps he'd be given the opportunity.
Okay. Thank you, Mr. Cooper. I'm going to move back. So
I guess so. You just would prefer to ignore a simple request, but perhaps he'd be given an opportunity.
Is that a point of order? That he be asked? So as the clerk has advised, that is not a point of order. It's a decision for the committee. The committee has made the decision. It's not a decision for the witness. So I appreciate your efforts, Mr. Cooper. They're always appreciated. So coming back, so Mr. Butts, before we moved on to the points of order, you've been given 30 minutes. That's exceptional for the committee, so I don't want future witnesses to consider it a precedent, but we think it's really important for you to be allowed to give your version of events. And now I'm going to give you the floor, and I appreciate you being here with us.
Thank you very much. I can assure all members of this committee that I will tell the truth. Thank you for having me here today. I would like to acknowledge that we are on the ancestral lands of the Algonquin people. I am not here to quarrel with the former Attorney General or to say a single negative word about her personally. What I am here to do is to give evidence that what happened last fall is in fact very different from the version of events you heard last week. It is based on direct communications with the former Attorney General and her staff, contemporaneous notes I took in meetings I attended personally, and debriefs from people who attended meetings I did not. I want to make 3 important points. First, everyone working on this file knew that the decision to direct the DPP to enter into negotiations toward a remediation agreement was the Attorney General's to make, and the Attorney General's alone. We also knew that that decision, whatever it was would have a real impact on thousands of people, and we took our responsibility to these people seriously. Second, I will provide you with detailed evidence that the January cabinet shuffle had nothing whatsoever to do with SNC-Lavalin. Third, this is a story of two people who hold high office, the Prime Minister and the former Attorney General, both of whom did their jobs to the best of their abilities, as did their respective staff. However, a breakdown in the trust that held the relationship together occurred, and as the point person in PMO for the Attorney General, I take responsibility for that breakdown. The Prime Minister gave and maintained clear direction to the PMO and PCO on this file. That direction was to make sure the thousands of people whose jobs were, and it bears repeating, are at risk, were at the forefront of our minds at all times. If anything could be done to protect those innocent people, we were told to work with the professional public service to make sure that option would be given every due consideration. He told us to keep in mind at all times that the decision to direct the DPP rests with the Attorney General and the Attorney General alone. We implemented that direction faithfully and with integrity. I was personally involved in the file on only a few occasions, but it was principally my responsibility to ensure that the Prime Minister's direction was followed by PMO staff. I have no doubt that they did so to the highest standards. So it was and is the Attorney General's decision to make. It would, however, be Canadians' decision to live with. Specifically, the 9,000 plus people who could lose their jobs, as well as the many thousands more who work on the company's supply chain. The Prime Minister believed that this is a real and significant public policy challenge that deserves a robust and thoughtful response. At no time did the Prime Minister or anyone in the government direct or ask the Attorney General to negotiate a remediation agreement. The former Attorney General confirmed that last week to this committee. So what exactly was staff talking to the Minister about? We had a view which was informed by Department of Justice advice that it would be appropriate for her to seek independent advice from an eminent Canadian jurist or panel of jurists. We believe that this was appropriate, first, because the law empowering the Attorney General to use remediation agreements is new. Indeed, this was the first time that entering into a remediation agreement under the new regime was even possible. Second, we felt that outside advice was appropriate because of the extraordinary circumstances of a conviction. The fact that the company involved employs so many people across the country heightened the public importance of the matter. That was the entirety of our advice to the Attorney General, which we made clear she was free to accept or not. We also made clear that if the Attorney General accepted our proposal and took external advice, she was equally free to reject or accept that advice. It was not about second-guessing the decision. It was about ensuring that the Attorney General was making her decision with the absolute best evidence possible. Fresh in our minds was a recent Federal Court of Appeal decision that had found that the government had not concluded consultation sufficiently in connection with the TMX pipeline. That was the substance of the discussions that the PMO had with the Attorney General and the Attorney General's office. When you boil it all down, all we ever asked the Attorney General to do was to consider a second opinion. I am not a lawyer, but I have extensive experience in government. When 9,000 people's jobs are at stake, it is a public policy problem. It was our obligation to exhaustively consider options the law allows and to be forthright with people in explaining the Attorney General's decision in order to be able to demonstrate that the decision was taken with great care and careful consideration of their livelihoods. We learned last week that the DPP made her decision not to pursue a remediation agreement on September the 4th, and that the Attorney General was out of the country until September the 12th. In that version of events, the Attorney General made the final decision after weighing all of the public interest matters and a new law involved in just 12 days. Imagine for a moment that on September the 16th, the day the former Attorney General told this committee the decision was made, firmly and finally, that she made a public announcement to inform Canadians of that decision. What would be the rationale? In fact, I learned for the first time while watching the former Attorney General's testimony that she had made a final decision on the 16th of September. My understanding is that nobody in the PMO or PCO knew that at that time either. In fact, it is not, to my knowledge, how the law works. My understanding, which was informed by the public service and lawyers in the PMO, is that the Attorney General's power to direct the DPP extends until the time a verdict is rendered. My further understanding is that the Attorney General is free to take advice on the decision up until that point and is obligated to bring fresh eyes to new evidence. I believe the former Attorney General confirmed this in her appearance here last week. The DPP considered the matter again itself in late September when new evidence was presented by the company, and the DPP made a fresh decision on October the 9th, 2018. It was in that spirit that Mathieu Bouchard and Elder Marquez had a discussion with the former Attorney General on November 22nd, 2018. They discussed a memo prepared by lawyers in the Department of Justice that described the option to seek counsel from an eminent jurist. It was also the subject of my and the Prime Minister's Chief of Staff's one meeting on this file with the Attorney General's Chief of Staff, which I will happily answer questions about. In any case, that was our operating assumption. The decision wasn't made, and we were free to inform it with advice. In the end, it was the Attorney General's alone to make, and it would be for all of us to explain. Most important, it would be for many thousands of people to live with. Following the September 17th meeting with the Attorney General had with the Clerk and the Prime Minister, I was debriefed that the next step on the file would be to have the Clerk and Deputy Minister of Justice meet with the Minister. That is my full recollection of the content of that meeting, which I can confirm I did not attend. That seemed like a prudent course of action to me, and I went back to doing what I was doing pretty much 24/7 in September, which was working on the NAFTA negotiations. If the Attorney General had made a decision and communicated it to the Prime Minister and Clerk, why would there be a next step at all? Why would the Attorney General take and solicit meetings on a closed matter? Moreover, why would the Attorney General not communicate her final decision in writing to the Prime Minister? Minister Wilson-Raybould's preferred method of communicating complex or important matters is in writing, which I very much appreciate. I have studied lengthy memos from the former minister on subjects as diverse as the appointment of a Supreme Court justice, the TMX pipeline process, and the work of the Cabinet Committee on Reconciliation. Yet in all our texts and emails, which begin the summer of 2013, there is not a single mention of this file or anyone's conduct on this file until during the Cabinet shuffle. I believe that if any minister is made aware of something they think is this wrong, I believe they have an obligation to inform the Prime Minister soon after they become aware of it. I spoke with the former Attorney General once on this file, on December 5th, 2018. In 3.5 years in government, we had one brief discussion about it. She raised it with me at the end of a 2-hour dinner at the Chateau Laurier Hotel. She requested the meeting via text message a few days earlier. On November 26, she wrote, "Hey there, GB, do you want to chat? I have a number of things to bring up. Maybe you do as well. Tomorrow after Cabinet, perhaps. Thanks, Jode." I replied, "Sure, I'm heading to Toronto right after, but could delay 10 minutes. She replied, "Happy to chat another time with you if heading to TO. Think this convo may be a bit longer than 10 minutes. We could not arrange our schedules to meet for a couple of weeks. It was a busy time. We were preparing for the G20, the new NAFTA signing ceremony, and the first Ministers meeting with Premier Ford. Minister Wilson-Raybould solicited the meeting with me. She also raised the subject with me. She asked if I had a view on the file, and I said I understood our offices were working together on ideas. We talked briefly about the idea of asking a retired Supreme Court justice for advice, but I noted that I had no expertise in the matter. I believe that the Harper comment she referred to was in the context of that discussion, Mr. Chair. She said that what Elder and Mathieu were proposing had never been done before. I said my understanding is that remediation agreements are brand new to Canada, and that the PPSC itself was not very old, having been brought into being during the Harper years. I was not making a partisan point, Mr. Chair. My suggestion was that it is a legitimate public policy discussion to have in this circumstance, and it would help clarify the Attorney General's powers in this and any subsequent case. I suggested she speak with the clerk or the public service for more expert advice. I said that it was her call, and I knew it was her call. I have no memory of her asking me to do anything or to speak with staff about any aspect of this file. At no time did the former Attorney General suggest to me that Elder and Mathieu had done anything wrong. The context of that meeting for me is that we hadn't seen each other in a while. We had both been busy with files that were not related to each other, and the minister and I hadn't really had a chance to have a good catch-up since we last had dinner at the end of July. I talked mostly about climate change, the pollution pricing policy, the Saskatchewan court challenge, and the strategy to deal with the First Minister's meeting. I also asked her advice on the LAV contract with Saudi Arabia. She had on her mind the civil litigation directive regarding Indigenous peoples and various other matters unrelated to the file you are examining. We parted that meeting as friends and colleagues and exchanged personal text messages a couple of hours later. I wrote, "Nice to see you." She replied, "Nice to see you too. Thanks for the convo. Please say hello to the PM. Heard him speaking my language in his speech. Good luck in Montreal. We stick to our guns/plan. We will be good." I just want to note that the reason she talks about that is I had left the meeting just to go meet the Prime Minister to go to the FMM in Montreal that evening. Finally, on Tuesday, December the 11th, the Minister texted me for the last time about the December 5th meeting. It read, "Hey there, couple of things. 1, KSA/LAVs. Thought about it more. Have some thoughts. Would not mind discussing. 2, RE Directive. I made most of changes from Elder already prior to Cabinet. Can this go out? Honestly not clear as to what result was at Cabinet. Here PM wants changes, but I am confident I have addressed all concerns. This is a big deal to me, as you know." The directive she is referring to is the Attorney General's directive on litigation matters involving Indigenous peoples, which was issued just before Ms. Wilson-Raybould became Minister of Veterans Affairs in January. As you will note, SNC-Lavalin is not mentioned in these exchanges at all. I am fully aware that two people can experience the same event differently. I believe that the minister shared my interpretation of our dinner, and I only quote these messages so you can appreciate why I was so surprised to hear months later that the minister experienced that dinner as pressure. I do not see how our brief discussion of that file constituted pressure of any kind. The second and final meeting I had on the file was with Jessica Prince, the minister's chief of staff, and Katie Telford. There was no urgency to attend that meeting. I remember that meeting very, very differently than the account given last week. I remember Ms. Prince saying that the minister didn't want to consider quote-unquote political factors in the decision and was worried about the appearance of political interference. I said that it's the minister's decision, of course, but to my mind, 9,000 people are not a political issue. It was a very real public policy problem. Either way, she decided, I could not see how having someone like Beverly McLaughlin give the minister advice constituted political interference. Ms. Telford's comments were reported here last week out of context. Ms. Telford was simply saying what we say all the time when legal matters come up in the presence of lawyers, that we are not lawyers and cannot debate the law. On the op-ed point, she was simply saying that we would do our best to support the minister, whatever decision she chose to make. That's the sum total of my personal interactions with the Attorney General on this file. A brief conversation at the end of what I thought was a good dinner, and a meeting with her staff where I sought to understand her reticence to receive advice from an independent jurist. This, to me, begs the entire question of what exactly constitutes pressure. According to the former minister's testimony, 11 people made 20 points of contact with her or her office over a period of close to 4 months. 4 of these people never met with the Attorney General in person. In my case, the Attorney General solicited the meeting. That's 2 meetings and 2 phone calls per month for the minister and her office on an issue that could cost a minimum of 9,000 jobs. The minister confirmed last week that nobody ever asked her to make or not make the decision. You now know that the subject of those interactions was whether she would take independent, external advice on the matter. Mr. Chair, we did what those 9,000 people would have every right to expect of their Prime Minister. The Attorney General could have written or spoken to the Prime Minister at any time during this process to say attempts to contact her office on the meeting were improper and they should cease immediately. The Minister could have told the people who raised it with her that they were close to or crossing a line. The Minister could have texted or emailed me at any time. However, the PMO's interactions with the Attorney General's office were only called into question by the Attorney General at the time of the cabinet shuffle. I'd like now to turn to my role in providing advice for that shuffle. The January cabinet shuffle had absolutely nothing to do with SNC-Lavalin. In fact, I spent at least as much time working to prevent the shuffle from happening as in preparing my advice for it. On December the 12th, Minister Bryson approached me and Ms. Telford to tell us he was not running again and that he would tell the Prime Minister later that day. and a Treasury Board chair with ministerial experience. No Nova Scotian except Mr. Regan had been a minister before, and he is the Speaker of the House of Commons. All signs pointed to Minister Philpott moving to Treasury Board. She had been Vice Chair, so she had the experience to do the job. The Prime Minister agreed with this, but he was worried about the signal it would send to Indigenous people. This, to me, is the saddest part of this whole story. Indigenous people have been sent precisely the opposite message from the one the Prime Minister intended. The most valuable thing in any government is the First Minister's time. The Prime Minister spends a lot of his on Indigenous issues, a lot. He cares about the relationship deeply. He was preoccupied with the fact that we had the Child and Family Services legislation coming up. He thought it would be one of the most important bills that the government would pass. He wanted a person in Indigenous services who would send a strong signal that the work would keep going at the same pace and that the file would have the same personal prominence for him. The right, and perhaps only person who could do that, was Minister Wilson-Raybould. The Prime Minister knew there were several capable and experienced lawyers in caucus. The short list for justice included several eminent lawyers with good backgrounds, including David Lametti. The Prime Minister chose Mr. Lametti because he is a distinguished McGill Law professor with graduate degrees from Yale and Oxford. He was also aware that it would raise eyebrows if he had 3 ministers and very large portfolios who all represented ridings on the subway line in downtown Toronto. That was the context in which the Prime Minister made the decision to move Minister Wilson-Raybould. It had nothing whatsoever to do with SNC-Lavalin. So the plan was a simple one, Mr. Chair. Philpott to Treasury Board, Wilson-Raybould to Indigenous Services, bring Lametti into Justice and Jordan into the new Rural Affairs portfolio that caucus had been lobbying for. It was a simple plan for a small, tidy shuffle. The situation started to change on the weekend of January 5th. The Prime Minister spoke to Minister Philpott in person, one-on-one, in his office on Sunday the 6th. The Prime Minister debriefed us right afterward. He said Minister Philpott was excited by the challenge, especially the digital government aspects of her new file. She said Minister Wilson-Raybould was an excellent choice for Indigenous services, but worried she would see it as a demotion. Minister Philpott then told the Prime Minister that she worried that Minister Wilson-Raybould might wonder if her move were connected to the DPA issue. That was the first time I ever heard anyone suggest that this cabinet shuffle was in any way related to the SNC-Lavalin file. The Prime Minister assured Minister Philpott that the shuffle had nothing to do with the file and asked her if she would help with the transition of her ministry to Minister Wilson-Raybould. She said that she would. After that meeting, I spoke to the Prime Minister privately. He was surprised by what Minister Philpott had said. I said to him that he had to factor into his thinking the possibility that the assertion she had made would be made publicly, however far-fetched it seemed. He replied that he knew that was not why he was moving her, and he would not change his mind. On January the 7th, 2019, the Prime Minister phoned the Minister of Justice and Attorney General to inform her that he was shuffling cabinet and that she would be part of that shuffle. I was present for the entire conversation, as was Ms. Telford. The following is from a contemporaneous note I took during the conversation. I also have the text messages Ms. Wilson-Raybould and I exchanged afterward, and I will summarize them. We would have many conversations in the following week, and I am at liberty under the terms of the Order in Council to discuss and answer questions about them. I will do so to the best of my abilities. The Prime Minister began the call by saying that Minister Bryson's sudden departure had put us in, quote, a tough spot. He said that he didn't want to shuffle cabinet, but that he needed our, quote, best players to move in order to, quote, pitch in. He said the Indigenous agenda was really important to him and to the country, as the Attorney General knew well. He said he didn't want to move Minister Philpott, but that she was the best qualified person to do Treasury Board because she had been Vice Chair. He then said that would leave a large hole at Indigenous Services, and he didn't want people to think he was relenting at all on the agenda. He said he knows how much she, quote, loves being Mojag, but that she was one of our top people, and moving her to Indigenous Services would, quote, show Canadians how seriously we take this. There was a long pause on the phone. Minister Wilson-Raybould said that she was, quote, a little bit shocked, unquote, because Mojag was, quote, her dream job. She said, IS is not my dream job. I'm not going to lie about that. The Prime Minister said, I know it is not your dream job, but it is core to this government's mission. Minister Wilson-Raybould said, quote, I feel I'm being shifted out of justice for other reasons. The Prime Minister replied that he was doing this shuffle because he had to, and because he thinks it's the best thing for the government and the country. He repeated that he wouldn't be doing it at all if it weren't for Minister Bryson's departure. He said, when you lose a team member, everyone else has to pitch in. The call concluded. Then Minister Wilson-Raybould did something I didn't expect. I had never seen anyone do it before in 13 shuffles over many years. The former Attorney General turned down a cabinet portfolio. She said she couldn't do it for the reason that she had spent her life opposed to the Indian Act and couldn't be in charge of programs administered under its authority. I want to say here, Mr. Chair, that I should have known that, and had we had more time to think of the cabinet shuffle, I probably would have realized it. I undertook to ask the Prime Minister to consider alternatives, but I also said I had never seen a minister turn down a ministry. The obvious question is, why did the Prime Minister not leave the minister in her old job if she turned down a new one? My advice was this: if you allow a minister to veto a cabinet shuffle by refusing to move, you soon won't be able to manage cabinet. Cabinet invitations are not the product of shared decision-making. My advice was that the Prime Minister should not set the precedent that a cabinet minister could refuse a new position and therefore remain in one position for the life of the government. Over the next few days, Ms. Wilson-Raybould and I talked and corresponded many times. I knew from those exchanges that trust had broken down between our office and the minister. I was deeply concerned by what the minister was saying. I tried to counter her misapprehensions with repeated and, believe me, honest efforts. In the end, I was unable to do so. And here we are today. I am firmly convinced that nothing happened here beyond the normal operations of government. Highly trained legal staff and PMO work closely with PCO's legal team on all aspects of the file to make sure that the Shawcross Doctrine was adhered to. I've had some time on my hands for the first time in a long while. I've used that time to review all of my existing texts and emails with Ms. Wilson-Raybould since we met on October the 3rd, 2013. There's a caricature in the press about what a relationship between PMO staff and a minister looks like. This, Mr. Chair, was not that. I came to trust Ms. Wilson-Raybould as a valued colleague and friend over the next 5.5 years. We had long, thoughtful, challenging discussions, both professional and personal. She and her husband, Tim, have had dinner at my house with my wife, Jody, and our children. To you, Chair, and to members of this committee, I want you to know this. I know it from long personal experience with the Prime Minister. If something improper had been happening and that impropriety had been made known to him, the Prime Minister would have put a stop to it, even if the impropriety were his own. I deeply regret that the former minister's trust and faith in the many colleagues she served alongside for 3.5 years has eroded so much, and I take my fair share of responsibility for that state of affairs. But what is happening here is not fair to the people named in her statement. They are good, hardworking people of extraordinary talent and integrity. They care deeply about their country, and they and their families have sacrificed much so they can serve it. I suspect that, like me, they learned of the former Attorney General's specific allegations against them for the first time last week, while watching this committee's proceedings. It is the highest honor of my professional life to have worked with all of these people, and so many others on so many important matters for so many years. I bear Ms. Wilson-Raybould no malice or no animus, and I wish her and her husband Tim well in the future. Most of all, I hope that this sad episode can be resolved quickly so the people who still have the privilege of being temporary occupants of high public office can get on with their vital work. I want to thank the many, many friends who have reached out over the past few weeks. Your kindness is the stuff of life. I hope that what I have said today gives you the context and rationale for my resignation that I could not give you before now. It is one thing to be accused of something on the front page of the paper. It is another to be accused of it by a friend and a cabinet minister. One happens all the time. The other had never happened to me before. The Prime Minister and I have been close friends for almost 30 years. That is well known. If I stayed on, his actions or inactions toward me could have been used to accuse him of playing favorites, that he was choosing his best friend over a minister. I could not allow our friendship to be held against him, so resigning was the right and necessary thing to do for the office and for the Prime Minister. I appreciate the opportunity to put that on the record, Mr. Chair. I hope my testimony today will provide the necessary information to allow the people I have worked with on critical issues, from climate change to job creation to helping people escape poverty, to refocus their energies and efforts on their vital work. Thank you all for your patience today, and thank you all from all parties for your many years of dedicated public service. I look forward to your questions.
Thank you very much, Mr. Butts, and thank you for your public service as well. So I'm going to just do what Mr. Rankin had suggested. I usually am very flexible in timing, but within these meetings, I am sticking to a fairly strict time frame. Before every round, I will remind everybody how long they have, and I will stick to that with respect to everyone, which means that given the short time frame, I would ask the witness to please be succinct in his responses to the extent he can, and to allow, and also to ask questioners to let the witness finish his answers unless he's really going on too long. And I will jump in at that point. With respect to the subject matter, let's all try to remember that the subject matter is the SNC-Lavalin issue. I will allow some latitude, but if I see that you're not getting to the point, then I'm going to remind you to get to the point. So hopefully that's fair with respect to what Mr. Rankin asked me to remind everyone. And then with respect to the rounds, do I have unanimous agreement to go to 3 rounds as opposed to 2 for this witness? Yeah, perfect. And then in the third round, I will again ask everyone before the third round, and perhaps I will even do it now. Does everybody agree that at the end of the third round, Ms. May and Mr. Weir can ask a question for 3 minutes each at the end of the round? Oh, excusez me, vous avez pas vu.
I didn't see you, and Mr. Plamondon as well can ask a question. Perfect. So 9 minutes at the end of the third round.
Mr. Butts' statement in English and French. Est-ce que tout le monde a la copie de... OK, parfait.
Everyone have the copies? Great, thank you.
In the first round, so that's why I want to make sure before we start questions that everybody has it. Mr. Butts?
Chair, I just want to point out that my statement is longer. The written statement is longer. I did my very best to shave it all down to meet the timeframes. So the written statement has additional detail in it.
Perfect. Thank you. Thank you very much. Now, all members of the committee have copies? Yes. Perfect. So the first round, 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. We'll start with Ms. Raitt. Ms. Raitt, the floor is yours.
Thank you, Mr. Chair. Thank you, Mr. Butts. Je sais que tous les Canadiens...
I know that all Canadians are paying close attention to the work of this committee today, and we're going to try to get some answers.
Thank you for noting the fact that your testimony is actually shorter than your written, but you did have an addition in your oral testimony that isn't in this. And I want to take you to it right now. And it's at the very beginning when you were talking about this notion of a legal of opinion, where you said, we had a view from the Justice Department that it would be appropriate for the minister, the Attorney General, to seek independent advice. And I assume I'd like to know when you received that view from the Justice Department, because it's a pretty interesting comment that PMO would get a legal opinion from Justice.
No, let me make sure I state that point clearly. The proposal was informed by a Justice Department memo, which I suspect you're going to want to talk to the Deputy Minister of Justice later about.
Okay.
That was where I believe it was an options memo, Ms. Raitt.
Yeah, and Jody Wilson-Raybould mentioned that, but how did you get possession of it, Mr. Butts?
I have no idea.
Okay, and do you remember around what time you received it?
No,
Okay, is it possible that it was before September 17th that you received it?
I don't think so, no.
Okay.
I remember it in the context, excuse me, sorry, I
course.
respect your question. Ms. Raitt, we've known each other a long time.
Yeah.
I believe it was in the context of the meeting of November 22nd, I think it was, between Elder Marquez and Mathieu Bouchard and Minister, I believe. But
So just to clarify, there were three different types of legal opinions that your PMO staff were talking with Ms. Jody Wilson-Raybould about, according to her testimony, and they morphed from one type of opinion to another, starting in one kind of opinion in September, and then. But I'm not going to ask you about that. I'm going to ask you this: did anyone assist you with your testimony today?
yes, I had legal counsel assist me and some friends who have nothing to do with the present government. You guys are used to this, I'm not.
I know.
So.
Did you discuss this with the Prime Minister?
No, I did not.
Have you had discussions with the Prime Minister since you tendered your resignation?
He called me once to wish me well. I will say, Ms. Raitt, this is the longest I've gone in 30 years without talking to the Prime Minister.
Fair enough. You mentioned texts and email addresses. Given what we're seeing in another proceeding with respect to the government and the use of personal cell phones, can you tell me if the texts with the former minister were with a personal phone or one that was issued by the Government of Canada?
These were with my PMO phone.
These were with your PMO phone?
Yeah.
You already told us that you made contemporaneous notes detailing
Yes.
the conversations
Yes.
you had. Mr. Marquez and Mr. Bouchard were clearly on this file, for the most part, on point. Did you have many meetings with them?
No, we looked through my calendar when I was preparing for, or I guess someone at the office looked through my calendar while I was preparing this testimony, and we could only find one meeting I had on this file internally.
Right. So what I'm troubled about, Mr. Butts, is you put out the view today that you were just asking the minister to take an external opinion to determine whether or not something or other, I don't know what the opinion was on, that was being sought. It's interesting that you mentioned Beverly McLaughlin in your written testimony as a potential person for external legal advice.
And I want to be clear on that, Ms. Raitt, because I don't want to put Ms. McLaughlin or anybody in the government in a difficult position, and in no way that was meant in the context of the Jessica Prince meeting. I said it's someone like Beverly McLaughlin.
I see.
Yeah.
Okay. Back to my original question, though. Mr. Bouchard and Mr. Marquez and yourself, according to Jody Wilson-Raybould's testimony, kept looking for a solution, not external advice. It would seem that you determined that there was a problem. Prime Minister determined there was a problem. You communicated with PMO that there was a solution that was needed. But you tell us today that you weren't looking for a solution or an action. You just wanted her to take another opinion. So who is right, Jody or you?
I am not here to call anybody names, Ms. Raitt, but I really don't think I would have used that word.
Okay.
I really don't. I can't be 100% certain. And if there were any problem that I felt needed to be solved, it was to make sure that all due consideration was given in both options. That's all. And if I can add, and I think this is an important point because, you know, people have made a lot of insinuations, and I think they've been based on speculation. I don't have a strong opinion. I mean, honestly, I don't envy either the former or the current Attorney General on this call. I really don't. I don't have a strong view either way.
Okay. Are you aware, Mr. Butts, that political considerations are not to be part of decision-making for the Attorney General?
Absolutely.
So why would the Prime Minister's office then condone several conversations, including the Prime Minister himself, bringing these elements into discussions with the Attorney General?
Well, I think there's a gray area in what you think is a political consideration, but I think you're also alluding to conversations I wasn't part of. I certainly never made any comment of the sort.
So the
to
Prime
Attorney
Minister
General.
never told you, he mentioned,
Sorry.
thank you. The Prime Minister never told you that he had made a point that he was an MP in Quebec, and Mr. Marquez and Mr. Bouchard never told you, or Mr. Chin never told you that they told Ms. Wilson-Raybould it was about an election in Quebec, it was about winning votes in Quebec and concerns about votes in Quebec.
No,
They never mentioned that to you.
No, honest to goodness, that's not true, Ms. Wright. And I.
What's not true? That they never
sorry,
told you, or
nobody
that they didn't say
Nobody
it?
told me.
Okay, fair enough.
But can I just have a moment to answer this? And I think this is really important. I respect you a lot, Ms. Wright, and we've known each other a long time, not so well, but we're both from the same part of the country. And as is Ms. May, we could have a Terrorbish game if there were one more Cape Breton around this table. You know, we grew up around the same time, in the same place. And we know what it's like to see a company or a community collapse. Mm-hmm. And can you imagine if when we were kids and the coal mines closed or the steel mill closed, the best explanation someone could give us was that someone thought about it for 12 days in Ottawa. And that's what concerned us. That is absolutely what concerned us. We wanted to make sure it was the first time the law was ever being used, and we just wanted to make sure that every due consideration was given to both options.
As a lawyer, I give due regard to the decision-making of the Attorney General.
I do too. I absolutely do.
Thanks. Thank you very much. I always like exchanges between Cape Bretoners. We'll now move to an Edmontonian, Mr. Boissonneau.
Thanks, Mr. Chair. Mr. Butts, thank you for joining us today. We've heard from Canadians, and they can't help but draw a negative inference from your decision to step down as Principal Secretary. Mr. Butts, if you did nothing wrong, why did you resign?
Well, I believe I covered that in my opening statement, Mr. Boissonneau, and I also covered it in my public statement. I think that I was put in the position where I had to ask my colleagues to fight another colleague over accusations a colleague was making. And I think that that put the Prime Minister in an impossible position, given the nature of our friendship.
In your statement following your resignation and today, you categorically deny the accusation that you or anyone else in the PMO pressured the former Attorney General. Yet we've heard her testimony very clearly at this committee that alleges otherwise. Why should Canadians believe your version of the facts?
Well, I'm not, as I said to Ms. Wright, Mr. Boissonneau, I'm not here to cast aspersions on anyone or to suggest that anybody is deliberately misleading anyone else. I do believe that it is possible for people to draw different conclusions from the same experience. All I'm doing here is representing to you, to the best of my abilities, the truth as I see it and the events as they occurred. I supplied some context in terms of contemporaneous messaging between myself and the former Attorney General. But I'll also say this, these are really important jobs, but at the end of the day, we're all people. And when trust breaks down amongst people, I think that it's easy to see things that have already happened in a different light.
Thank you. In your statement, you said that it was important that the former AG be able to provide a rationale for not giving a remediation agreement to SNC-Lavalin. In your mind, why was it important that she be able to give a rationale for not giving a remediation agreement to SNC?
Well, a couple of things. One is the legality of the legalities, the law on this is very fresh. And we thought it would be an appropriate step to get seasoned, eminent advice from a jurist that would help flesh out the process around the law. And that's all we were trying to do. There was nobody trying to make the AG make one decision or another.
So in your testimony today, as I understand it, your discussion with the former AG was about that need for a rationale, was the substance.
Yeah, I mean, It's the discussion I had with the AG was literally, as I recall it, as we were about to get up from the table after 2 hours of talking about a bunch of other things. And, but yeah, that's what it was about.
That's helpful. Ms. Wilson-Raybould shared her perspective that it was appropriate for colleagues to draw her attention to important policy considerations related to this issue, as you've done today, related to jobs. Yet when this pressure veered into the realm of provincial politics, she then deemed it inappropriate. So do you believe that successive meetings and raising such issues was appropriate?
What do you mean by such issues?
Well, members of the PMO talking about the fact that provincial politics are coming, that there's an election on the horizon.
I'm not going to pass judgment on what anyone else did, Randy.
Okay.
Mr. Boissonneau, excuse me.
Do you believe it was appropriate for people to speak with her at all after she had said that her decision was final on this matter?
I do not recall, as I said in my opening statement, that she ever said that. And I'm not sure why. I mean, my understanding of the law, and I will say to you what I said to Ms. Prince on
Sure.
December the 18th or whatever that was. I'm not a lawyer, so I'm always very hesitant to get into detailed discussions of the law. And that is particularly true in my interactions with the Attorney General. So I don't know what I can say on that, Mr. Boissonneau.
No, that's fair.
Yeah.
So in your role as the former principal secretary, you would have been privy to many important meetings.
Correct.
I'm interested to know if you ever witnessed inappropriate pressure on the former Attorney General.
No.
Would you have raised the issue with the Prime Minister? Had you ever witnessed a colleague inappropriately pressuring the former Attorney General?
Absolutely.
Thank you for that. We heard from Michael Warnick's testimony that while there may have been pressure, none of it was inappropriate, undue, or lawful. I think he said lawful advocacy. He stated that Canadians ought not to be worried about the rule of law in this country. Are you worried about the rule of law in Canada?
Absolutely not.
Why? Why not?
Because, and this is one of the things that I think is really important to keep in mind. I've seen a lot of things over the last 3.5 years, interfaces with other governments in other countries, and in a lot of places, public institutions, excuse me, are faltering and failing, and they're faltering and failing in countries that look just like ours. Canadians should have faith in their public institutions, and they should have faith in their public institutions because they work. I have absolute confidence in this committee, in Parliament, in the independence of the justice system, and in the professional public service, and in the powers of the Attorney General's office, which I want to say, Canadians should feel protected by the powers and conventions governing the relationships between these offices, not by the presence of any individual at any given time.
At any point, Mr. Butts, did the...
Sorry, your time has expired.
Thank you.
Mr. Rankin.
Thank you, and good morning, Mr. Butts. Thank you for being here. I'd like to read you from the letter of resignation by Ms. Philpott from 2 days ago and ask if you agree. She says, unfortunately, the evidence of efforts by politicians and/or officials to pressure the former Attorney General to intervene in the criminal case involving SNC-Lavalin and the evidence as to the content of those efforts have raised serious concerns for me. The solemn principles at stake are the independence and integrity of our justice system. Sadly, I have lost confidence in how the government has dealt with this matter and how it has responded to the issues. Finally, she says, I must abide by my core values, my ethical responsibilities, and constitutional obligations. I take it from your summary that you have a complete disagreement with her conclusions.
Well, I certainly don't have a disagreement with her conclusion in the sense that she's lost confidence. That res ipsa loquitur. And by the way, I should say congratulations on your retirement, Mr. Rankin.
Thank you.
I've been an admirer of yours for many years. Obviously, my opening statement details at length that I disagree with the former minister's perspective on this, yes.
All right. Now listen, I want to talk to you about two events. December 5th, when Jody Wilson-Raybould met with you, both sought out a meeting, and she testified that I wanted to speak about a number of things, including bringing up SNC and the barrage of people hounding me and my staff. Do you recall her saying that?
No, I do not.
So you have no memory of that. Now, on December the 18th, 2018, you've talked about the Chief of Staff, Jessica Prince, meeting with you and Katie Telford. And according to a text that was read to us by Ms. Wilson-Raybould, which I'm sure you remember, she said, Jerry said, Jess, that's Jessica, there's no solution here that doesn't involve some interference. Then she says, I guess they're finally being honest about what they're asking you to care. Don't care about the public prosecutor's independence. Katie was like, we don't want to debate legalities anymore. They kept being like, we're not lawyers, but there has to be some solution here. What solution could possibly exist if it did not involve inappropriate political interference?
Well, I think I went through that in some detail in my opening remarks, Mr. Rankin. I have a very different recollection of that meeting. And I don't think I would have used the word solution because it's not one I would use in this context. But, you know, my basic point to Ms. Prince was that if getting advice from someone like Beverly McLaughlin constitutes political interference, then it must be your position that you can't have a conversation about this file.
But if she rejected that, if that became clear at some point in time that her mind had been made up, would it not be reasonable for us to infer that that barrage of hounding, to use her words, was happening? Because she told people at the highest level of your office, she wanted them to back off. Her decision was made up. Whether that was a good decision or a bad one is really not for us to talk about. It's just the way in which that was communicated.
Well, I would make a couple of points on that, Mr. Rankin, with respect. One is, I don't think it was possible for her to have her decision made. My sense, and as I was briefed by the professional public service at the time, was that she was obliged to bring fresh eyes every time new evidence arose. And
was there any new evidence? What new evidence? We've never heard of any new evidence.
There must have been, I'm not aware of any, but there must have been there must have been some reason for the DPP herself.
So you would accept that if there were no new evidence, that it would be inappropriate to continue to push her, having demonstrated, as she had said so clearly by that point in time, that her decision as independent Attorney General had been made up?
No, I would not accept that. I would ask professionals for advice on it if that were in dispute.
Because you said, I think, in your testimony that up until the verdict, it's always appropriate to talk.
That is my understanding of the law.
All right.
Yeah. As I was briefed.
So my next point, Mr. Chair, is that the witness talked about a conversation with the Prime Minister concerning the removal of Ms. Wilson-Raybould from Cabinet. I point out to everyone that we don't have the ability. She refused to talk about that appropriately because the waiver that was given to her by the Governor and Council did not allow her to talk about it. So we only have one account of that very critical meeting. So I'd ask for the record that we called the witness back after the Governor and Council liberates her to talk about the balance of this, or we'll never know what truly happened. I just think that's obvious.
So, Mr. Rankin, with respect, my understanding is not that. My understanding is that I am covered by exactly the same waiver liberty, whatever you want to call it, that the former minister was when she was here. The event I'm describing, the two events I'm describing, the conversation the Prime Minister had with former Minister Philpott and with former Minister Wilson-Raybould happened successively on Sunday, January the 6th, and Monday, January the 7th. And my understanding is that the waiver covers the events up until the 14th.
So her testimony, people will recall, members will recall, was that she could not tell us about those events. So I'm told now that she can. So therefore, we need, with great respect, to hear account of the same, her account of the same event.
You're noted. Your time is now up, Mr. Rankin. I think it's up to every witness to determine for themselves what the order of in council covers. So I believe she. I believe that she did speak to these events at the committee, but we will take under advisement your comments. And I do note the witness's comment to Mr. Rankin, and I think from all of us who have served on the committee with him for the last number of years, his intelligence, his integrity have always been incredibly appreciated at this committee, and it will be a real loss to politics and to Ottawa and to the national parliament that you will no longer be here after the election. Thank you. We'll now go to Mr. Boissonnault again. Mr. Boissonnault.
Thank you, Mr. Chair. Mr. Butts, ministers face a ton of political pressure. I think you alluded to that. Former Solicitor General Wayne Easter indicated, quote, that there's always pressure in government, and what one person sees as pressure, another may just see as a day's work, end quote. Minister Freeland has said, quote, I always feel that when there are difficult issues, that if it comes to it, I should go personally to the Prime Minister to discuss them. I really think it's my duty to do that, end quote. Are you aware of any instances in which the former Attorney General raised this issue of pressure with the Prime Minister?
I am not, no.
Are you aware that she availed herself of any of the opportunities that she could have had with the Prime Minister to raise this issue?
I am not.
At any point, did the former Attorney General ever raise the issue of pressure with you directly?
No.
So we've heard testimony from the former Attorney General that she felt pressure even after she asked or told us.
I'm sorry, your time has stopped. There's something with interpretation going on right now. Est-ce que l'interprétation ne marche plus?
Is the interpretation no longer working? We're just going to wait until the interpretation works again?
51 seconds, Mr. Boissonnault.
Elle a repris maintenant.
C'est repris. Est-ce que vous pourriez confirmer que c'est...
Has resumed. Can you confirm that the interpretation has resumed?
It's working now, Mr. Plamondon? C'est beau, c'est beau. Ok, merci.
Okay, yes, it seems to be working.
We heard testimony from the former AG that she felt pressure even after she asked members of the PMO to stop. As per her own testimony, after the September 17th meeting, she agreed to take another meeting with the clerk and her deputy minister. Then on September 19th, she asked that SNC send in a letter. Also on that day, she sought out Minister Morneau on this issue, and her chief of staff on September 19th and October 26th invited conversations between the Prime Minister's office and herself. Why did your former office keep speaking to her after the former AG had indicated she'd made a decision?
Well, as I outlined in some detail in my statement, I do not believe that we were aware that the AG had made a final decision at the time.
So what were you trying to achieve then? Getting an external opinion or getting more information on the issue?
I can only speak to the meetings that I was personally associated with or involved in, and in my case, I still don't quite get why getting transparent advice from a Supreme Court justice on this matter is controversial at all.
Okay, so constituents and Canadians are curious about how many meetings actually take place on a big government file, and you mentioned a file that's important to me. So on a matter related to 15,000 jobs in Alberta and the West,
right.
Billions of dollars of economic development, the idea to buy the TMX pipeline would have been a new idea. And that would have prompted a number of meetings between the Prime Minister's office and the Ministry of Finance. So how many meetings, ballpark, would the PMO have had with the Finance Minister's office over the purchase of the TMX pipeline?
I feel like we had at least that many meetings with the affected Premier's office.
So what, 5 meetings, 50 meetings, 30 meetings? How many meetings in the first couple of weeks on TMX?
On the TMX acquisition, I would say, I wouldn't want to venture a guess,
Ballpark.
but it probably 100.
So is that normal for a file that's this big?
A file that big, for sure.
Okay, so affecting thousands of jobs.
NAFTA would be a week in NAFTA.
Fair enough. Okay, well, that's helpful. Now, I know that the AG has a different standard when it comes to pressure. So, Mr. Butts, on a matter of great importance that affects thousands of people on which the AG must make a decision, in your experience, what's the typical number of meetings that a PMO would have with an AG or their team?
Well, I think, and I say this with great appreciation of everybody involved.
Yep.
We're talking about people who had long-standing personal and professional relationships, and I seek to disparage none of them because I think it's hard enough to get people to contribute to public life in this country, and everybody involved has made great contributions. This was a novel law. It was the first time it had ever been used. So we thought the bare minimum we needed to do in order to look people in the eye who stood to lose their jobs was to make sure we had a good reason and to build process around that. And it's absolutely bare minimum to get the best advice you can when a decision affects that many people. And there's not much more to this than that, in my view, Mr.
Along
Boswell.
that line, then, you take a look at a file like TMX, you take a look at this issue, you take a look at even the Supreme Court reference that you alluded to. So why only 10 meetings over 4 months on an issue this important?
I honestly, I don't know.
Okay. Was there a coordinated effort within the PMO to try to get the former AG to change her mind on the SNC file?
No.
And you can...
100%.
How do we... 100% no? How can we believe that statement?
Well, one would expect that if such an effort existed, then I would have been aware of it, and I was not. And I know the people involved very well. Mathieu Bouchard and Elder Marquez are incredibly accomplished lawyers of sterling reputations. And it is inconceivable to me that they would engage in this sort of behavior.
I appreciate that. Final question. We've heard testimony and read in media articles that implies there was something inappropriate about raising provincial elections. I know there's one coming up in Alberta, for example. So in your experience, in the context of intergovernmental affairs, how are electoral considerations addressed on such big government issues?
Well, let me give you an example that is contemporaneous with the events you're describing. It was becoming really clear as we approached the end of the NAFTA negotiations that whatever settlement we came to on dairy policy was going to have a really large impact on the Quebec election. That did not stop us from signing NAFTA.
Thank you.
So that concludes the first round. On va passer au deuxième round des questions.
We're going to move to the second round now.
6 minutes to the Liberals, 6 minutes to the Conservatives, 6 minutes to the Liberals, 5 minutes to the Conservatives, 3 minutes to the NDP. We're going to start with Mr. Fraser.
Thank you very much, Mr. Chair. Mr. Butts, thank you so much for being here. It's good to see you. I want to say thank you as well for your public service. And I know you commented on others who serve the Canadian government so well. But I think your long career of public service should be duly noted as well. And I want to thank you on behalf of all of us here. I'm wondering if you would be interested in tabling some of the text messages that you referred to in your statement.
So my understanding, and I worked with counsel on all of getting access to all of the documents I needed for this presentation and this conversation. My understanding is that is not my decision to make any longer.
Okay. I want to follow up on a question that Mr. Boissonneau was asking you a moment ago regarding a coordinated effort in the PMO, and your answer was very clear. I just want to ask, did you direct or even encourage anyone in the PMO to try and pressure the former Attorney General to approve a remediation agreement?
Absolutely not. And as I said before, I really don't have an opinion on what decision either the former or the current Attorney General could make, and I should make, and I am quite happy that I am not in their shoes.
And as well, to your knowledge, in the close working relationship you had with the Prime Minister, did the Prime Minister ever direct or encourage anyone in the Prime Minister's office to try to pressure the former Attorney General to approve a remediation agreement or anything else with the former Attorney General?
Absolutely not.
I want to turn for a moment to the couple of meetings that you mentioned in your statement. The first one on December 5th, when you had dinner with the former Attorney General at the Chateau Laurier. You had said that, I think November 26th was the date that she had texted you and said that she would like to have a conversation with you, and it was going to take longer than 10 minutes, and then later it got coordinated to be a dinner at the Chateau Laurier. She mentioned in her statement that it was a meeting that you both had wanted. Is that fair to say, or would you say that it was her asking you for the meeting?
Well, I'm not sure they're incompatible statements, to be honest. I certainly responded very quickly, and I always enjoyed meeting with Minister Wilson-Raybould. So it wasn't like she had to drag me to the Chateau Laurier Hotel.
Okay, and you'd mentioned as well that there were a number of items that were, I guess, discussed at that meeting, which would be in the normal course of things with the minister whom you were friends with and had a number of issues that you wanted to go through. SNC-Lavalin came up in a brief discussion near the end of that conversation. Is that your recollection?
Absolutely, yeah.
And when that issue came up, what can you tell us about what was discussed regarding SNC-Lavalin at that meeting?
I covered all that I can recall in my opening statement, Mr. Fraser, and I didn't give it a moment's thought at the time afterward. I just thought, I guess Minister wanted my perspective on that.
And in the conversation, she was the one who brought up that issue?
Correct.
With you? And Mr. Rankin mentioned a moment ago that in her testimony, she said that there was a barrage of people hounding me and my staff, and she wanted to bring that to your attention. You didn't recall that. Do you recall her saying anything regarding anyone inappropriately pressuring her or feeling like she was not being treated fairly with regard to this matter?
No, and I believe that I would have done something immediately about it. I was heading to the airport to meet the Prime Minister to go to the First Minister's meeting in Montreal, and I would have done something about it.
And in the follow-up text messages and communication you had with her afterwards, it seemed as though to I guess corroborate the fact that it was a cordial meeting that you had. It was a nice dinner, and that there was no difficult discussions.
Yeah, Minister Wilson-Raybould and I would have dinner maybe 2, 3, sometimes 4 times a year. And we'd catch up on a whole lot of things. I mean, I learned a tremendous amount from her, and I have a lot of respect for her. You know, this is a very unfortunate series of events.
Was there any briefing that was done with anyone else after the December 5th meeting, from your point of view? Anything related to?
I may have mentioned the next day in Montreal that I had suggested, or I usually debrief Katie, Ms. Telford rather, or the clerk maybe. I don't know. I don't have a clear recollection of it, to be honest.
Okay, and it was quoted that you had said that you disliked the law and we need a solution on SNC stuff, and you made comment about that that's not the way that you would have characterized that.
No, and I appeal to the firsthand knowledge of the people who have worked with me over the years on very delicate, sensitive matters, including many of you around this table, and ask you whether or not that is in keeping with my character to do such a thing.
Okay, and the Harper era law that you were talking about, you talked about the fact that there was a director of public prosecutions brought up, and that happened in the time that Stephen Harper was the Prime Minister. That was the context of that.
Yeah, that's it. It was a chronological point, not a political one.
Okay, thanks very much.
Thank you very much. Ms. Raitt?
Mr. Butts, you said that you reviewed your texts since you have resigned from PMO. How did you still have possession of your government phone?
I acquired the ability to review my texts through my counsel. I do not have possession of my government
You don't have your phone, so you received the access to the phone? Is that what you're saying?
However, my legal counsel got the texts. That's how I got them, through my legal counsel.
So they did a review of records and they produced the texts to you?
I'm not sure what you're asking, Ms. Raitt.
I'm asking how, if you gave up your phone when you left the PMO, that you still had access to the phone to produce the texts today. You said you didn't. You received it from your legal counsel.
That's true.
And I'm asking who then picked the texts that you were to receive and look at.
You may recall there was a small story on the front page of the Globe and Mail about this a few weeks ago. And when that story ran, I said to myself, actually it wasn't when the story ran, it was the next day, when I got a very specific question from the Globe and Mail through the office directed at me about my meeting with Minister Wilson-Raybould. I believe they were even specific enough to say at the Chateau Laurier Hotel. where my first instinct was to look at my phone and see if I remembered it as correctly as I thought I did.
Okay, talking about the cabinet shuffle, your testimony is it wasn't about SNC-Lavalin. So why was the Deputy Minister of Justice told that why did the Deputy Minister of Justice say that the Prime Minister wanted to talk to the new Attorney General about SNC-Lavalin matter first thing?
I have no idea. You'd have to ask the Deputy Minister of Justice that.
Okay. Do you believe that SNC-Lavalin was entitled to a deferred prosecution agreement?
No, absolutely not.
I'm going to read you a part of the mandate letter. Did you draft the mandate letters for the ministers? Did you have a hand in drafting the mandate letters?
I'm not sure. I think that's a subjective standard. I probably read them before they were sent, but I don't think I...
Right.
Yeah,
well,
had
one
a
interesting
heavy-handed
piece for me is that the Attorney General of Canada, you are the Chief Law Officer of the Crown, responsible for conducting all litigation for the federal government and for upholding the Constitution, the rule of law, and respect for the independence of the courts. That would seem to be the marching orders for the former Attorney General of Canada.
I would agree with that.
And she was discharging her duty during this entire time.
I believe so. I have no reason to believe she wasn't.
Okay. You mentioned a minute ago, Mr. Butts, that Elder Marquez and Mr. Bouchard have a sterling reputation and they would not engage in certain matters of politics. Now, I want to take you through the chronology because what I find interesting is it was consistent how many times attempts were made to either get directly to the Director of Public Prosecutions, which is completely not acceptable. The only connection between the Director of Public Prosecution and the government is through the Attorney General. Would you agree with me on that?
I would agree with that, yes.
So when Ben Chin started negotiating on behalf of SNC-Lavalin, indicating what they were prepared to agree to, as one of the chiefs that report to you, do you find that to be acceptable?
Sorry, could you repeat that?
So Ben Chin, on September 6th, said that SNC's legal counsel was former Supreme Court Justice, and he also indicated that SNC was prepared to agree to certain things in order to get a deferred prosecution agreement. That's the testimony of Jody Wilson-Raybould. If he did that, is that acceptable behavior in your opinion?
I'm not going to answer a conditional question like that because I don't know if he did it.
So Mr. Bouchard and Mr. Marquez said on September 16th.
But can I say something in response to
I
your
have a whole list of these guys.
I can imagine you do.
Okay.
But about this idea that someone tried to directly interfere with the DPP, on February the 12th, my understanding, when making a public comment on another matter, which is the one I think you were alluding to earlier, which we should not discuss here, my understanding is the DPP said that there had been no political interference in that matter or in any other matter.
Correct, but what I'm talking about, Mr. Butts, are the attempts to be political. And I'll bring you one more. Matthew Bouchard and Elder Marquez said, according to Jody Wilson-Raybould, that the individual Crown prosecutor wants to negotiate an agreement, but the director did not. How would members of your PMO staff have knowledge of what a single Crown prosecutor would know or not know about a DPA?
I have no idea whether or not that is factually correct.
Okay, as well, they indicated that the Deputy Minister of Justice thinks that she can get the Public Prosecution Service of Canada to say that we think we should get outside advice. So that's Prime Minister's office, Justice Minister, Justice Deputy Minister going directly to the Director of Public Prosecutions. Would you agree that that's not acceptable?
I don't believe that they did.
You don't believe that?
They went
so you don't
directly
believe the testimony of Jody Wilson-Raybould?
That is not what I'm saying.
Well, this is her testimony, and this is what I'm saying. On September 19th, both again raised the idea of an informal reach out this time to the Director of Public Prosecutions. How is that acceptable as an indication from the Prime Minister's office to suggest an informal reach out from either the Deputy, the AG, or even a member of the Deputy's staff? How is that acceptable when we know the line between Public Prosecution Service and the politics of this country is very clear?
I agree. Can I answer it though, Mr. Chair?
I wanted to let you know that that's
okay. I agree that it's very clear, and I just want to go back to the substance of my evidence I'm providing here. I think that I don't think I know the people involved. I worked with them closely. I know the file a little bit, it just doesn't ring like something they would do on this or any other matter.
Thank you very much. We're going to Mr. Fraser now.
Thanks very much. Mr. Butts, I just want to pick up where I was earlier and go to now to the meeting of December 18th that you had with Katie Telford and the former Attorney General's Chief of Staff at the time. How commonplace would it be that you would have a meeting with a Chief of Staff regarding an important matter that was of concern at the time?
Very. We met with Chiefs of Staff all the time, both together and separately.
Okay. How did that meeting actually come about? Who actually coordinated that meeting?
I don't recall. I mean, it was, as you say, my answer to your first question, Mr. Fraser, is that it was very commonplace for such meetings to happen. It wouldn't have been unusual. In particular, at that time of year, Ms. Telford and I tried to meet with Chiefs of Staff at the end of sessions to check in and see how things were going, that kind of thing.
Okay. In her testimony, the former Attorney General had indicated that she had received a text message from her Chief of Staff shortly after the meeting indicating that the meeting was, that she was urgently summoned to the meeting. Does that sound like a fair characterization of your meeting?
I can't think of a single instance in which Ms. Telford and I urgently summoned anyone. But as I said about my dinner with Ms. Wilson-Raybould, people can come away with from the same experience with different impressions. So I have said many times, as I'm sure you've heard me say in caucus at points, Mr. Fraser, that the longer we are all in these jobs, the more people see us as these jobs and not as people. And I think that carries with it a responsibility to be conscious of power dynamics between people. And I like to think, and nobody's perfect, but I like to think that Ms. Telford and I were very conscious of that.
Would you say it's fair to characterize that the main tenor of that meeting on December 18th was in order to discuss retaining external counsel to give an opinion about the correctness of a DPA?
I believe that's a fair characterization, but I can't be sure. And I know that the biggest contentious issue that we were discussing with the Minister of Justice and Attorney General's office at that time was the directive on civil litigation matters involving Indigenous people. And there were concerns in different places with different people and different ministries. And most of the discussions that I recall between our office and theirs and hers at that point in time were about that subject. So I'm sure that came up as well.
It was indicated in the text messages from the Chief of Staff to the former Attorney General that you said that there was no solution here that does not involve some interference. What do you say about that?
Well, I think I answered that question a little while ago, Mr. Fraser, but that is not what I said. I do remember that part of the conversation, and I think this is the heart of the matter here. Does asking for external advice constitute political interference? And I think by any reasonable definition of the term, it does not.
With regard to Katie Telford, you were in the meeting and Katie Telford had indicated about arranging op-eds. And I know you touched on it earlier, but can you expand a little bit on exactly your understanding of that comment that was made?
Yeah, it was, it's not a sophisticated tool in politics to ask your supporters to support you, right? And it's a common practice. It's probably been around as long as there have been op-eds, that whatever position the government is taking or an opposition party is taking, they seek out supporters in the free press.
I want to just return for a moment to your opening statement where you mentioned that there seemed to have been a breakdown in the relationship with the former Attorney General. Can you explain how you arrived at that conclusion and when that happened?
I think, from my perspective, I felt like Ms. Wilson-Raybould and I, for most of the time, we worked together, whether going way back to her nomination and the election campaign, which you will all remember was not a smooth sail across a calm sea. I felt like we could generally work things out. And I think in the context of the cabinet shuffle, that became very difficult. And I think that's when trust broke down.
Okay. Thank you very much. Those are my questions. Thank you very much, Mr. Fraser. We go back to the Conservatives. Ms. Raitt.
Mr. Speaker, Mr. Chair, I would like to move a motion, please, that the witness produce all communications, texts, emails, written notes between himself, Jody Wilson-Raybould, Matthew Bouchard, Elder Marquez, Katie Telford, David Lametti, Jessica Prince, Ben Chin, Bill Morneau, and Justin Trudeau.
Do you have it written out anywhere, Ms. Raitt, to be able to?
Only in my BlackBerry.
Can I ask a question? Can you write out, would you mind writing out the motion and then allowing Mr. Cooper to ask the questions in the rest of your time and then coming back to the motion when everybody can get a copy, and I'll give you back the time to put
Well, I'm
forward
going
the
to ask
motion?
questions in this round right now, Mr.
Oh, yeah, I'm sorry. I
Chair,
thought Mr.
and
Cooper was asking about-
Certainly, yeah, certainly I'm fine with that. So
Sure,
I'll
sure, yeah.
continue?
Yeah.
Okay. Mr. Butts, did you know that on September 17th, Jody Wilson-Raybould indicated that she instructed her staff to ensure they had a very detailed chronology of all meetings and conversations about the SNC-Lavalin and deferred prosecution agreements because she was worried about what was going to be happening in the coming months? Were you aware of that?
I was not aware of that, no.
Well, she did, which I found interesting. As we were talking about what the Prime Minister office staff was doing to try to get to the Director of Public Prosecution, the second type of legal opinion that was sought was different, and this time it was a legal opinion sought on the actual director's decision to not grant a deferred prosecution agreement. Were you aware that Mr. Elder and Mr. Bouchard requested that?
I'm not even sure I know what that means, Ms. Raitt, to be honest. It
Okay, well-
sounds, you are a lawyer, correct?
I am.
I am not.
These are important issues, Mr. Butts, and because you're testifying here that you are the link between the Prime Minister and the Prime Minister's office, and yet the Prime Minister's staff was clearly over the line of appropriateness. That's testimony from Jody Wilson-Raybould, and that's my assumption based upon the fact that she put forward. So at the end of the day, you are responsible for these matters, and your responsibility flows up to the Prime Minister.
That is correct. I'm also testifying that if anyone crossed a line, it is the responsibility of the minister to inform somebody about that. And I'm presenting myself as the most likely person that would have been informed, and I was not.
So in her testimony, when she indicated that she brought it up with you and said it was inappropriate, your testimony is you don't recall it that way.
My testimony is that I recall a very different conversation, yes.
And that she did not tell you that it was inappropriate for people to continuously ask her about her decision after she had made it?
Well, I think whether or not she made it is the subject of some debate.
Well, let's go back to that.
I will say that if a minister, any minister, especially the Attorney General, spoke to me and said that a member of my staff or any other staff were pressuring them in an inappropriate way on any matter, I would have spoken to that staff.
So let's go back to the Section 13 memo that was written for the Attorney General. For background, when the Director of Public Prosecution determines there's a matter of public interest that she needs to inform the Attorney General, she writes a memo that is only for the Attorney General's eyes personally, does not go to anybody else. And she lines out exactly why she's taken the decision and why it is important. How often did you receive in the Prime Minister's office written instruction from the Attorney General on what she had did or did not do on a Section or Article 13 request from the Director of Public Prosecutions?
I'm not aware of any.
Never. So why would you testify that you thought that she should have provided written commentary or written notice to the Prime Minister's office?
I didn't say she should have provided written commentary on
I think you did in your testimony,
a
Mr.
Section 13
Butts.
order. I did not. What I said was that if she had made her mind up on a matter, she did not have to disclose the content of the order. She could have simply informed us that her mind was made up and that any attempt to open the subject with her was inappropriate. And I think that a fair evaluation of the events of the fall suggests that that was not the case, that further meetings were welcomed and solicited, and advice was also welcome.
So your testimony is that on the occasion that the Director of Public Prosecution sends a note to the Attorney General indicating a matter of public interest, that the Attorney General has the obligation to inform the Prime Minister's office of a decision she took, because that's exactly what you just told us.
No, that's not exactly what I just told you. What I told you was that if her mind were made up on the matter, she need not disclose anything about the content of the order. And my understanding is that that would be inappropriate if she did. But if there were ongoing discussions, which she is welcoming, the minister is welcoming, and in some cases soliciting, that it is inconsistent with the supposition that her mind is made up, and it is also inconsistent with our understanding of the law and the way we were briefed on how the law operates, because no verdict had been rendered in the case, and it was possible that new information could come to light. And in fact, not only was it possible, it happened in the case in this case, when the DPP rendered a fresh judgment on October the 9th.
So
Your time on questioning is expired. Do you want to move the motion now? So we have a copy by email, but I don't know if there's a copy that members could get. Did anybody write it down on a paper or anything that members could get distributed?
No, but you can read
We'll read it into the record. Well, it's not that long. Maybe people can do it without a written document. Ms. Raitt, go ahead.
I don't have it in front of me right
Oh,
now.
so Ms. Raitt, would you like me to read what you
have
have?
it? Would you read it for me? That would be
So,
excellent.
yes. So what we have from Ms. Raitt, colleagues, is that the witness produce all communications, texts, emails, written notes between himself and the former Attorney General, Jody Wilson-Raybould, Matthew Bouchard, Elder Marquez, Katie Telford, David Lametti, Jessica Prince, Ben Chin, Bill Morneau, and Justin Trudeau. Is that correct, Ms. Raitt, as to be your motion?
I'm going to take your word on it. Yes, it sounds right. It's
So-
all the players.
So
Yes.
may I just make a comment as chair? That in itself would be beyond the scope of what we're doing. I think you mean to add in at the end the words related to the prosecution of SNC-Lavalin. Because that would be the terms, right? Okay, so then it would be receivable. I just also want to clarify with the witness, I believe before when Mr. Fraser asked if the witness could produce certain texts, I believe there was a reason that the witness said, wanted to advance that he couldn't, which is that he's no longer part of government and he doesn't own these texts, and it's not up to him he can't produce them. Is that correct, Mr. Butts?
That is correct. They're not under my control.
So I think that the words that the witness produces probably also then no longer the right words that the committee asked for perhaps might be the right words. I leave it to you, Ms. Raitt.
Well, the witness is indicating that he can't produce them on his own, but his counsel can certainly ask for it if he wants to. But if you think it's more, look, we want to get to a result at the end of this, and the result is we'd like to have copies of those items since the witness came forward and indicated he had these items. It would be very helpful to see these items. So if I'm in your hands, if you think it's easier for us to go ahead and ask for it in a different way than through the witness, then that would be fine.
Let me check with the clerk. Yep.
just can read.
Thank you very much. So the clerk is suggesting that the words that the witness be replaced by that the office of the Privy Council.
That sounds great. Thank you.
Thank you very much. So then I judge the motion receivable, and then debate. I have Mr. Boissonneau, but Ms. Raitt, do you have anything further to say before I pass it to Mr. Boissonneau?
On the top, I just want to make sure that we're not just capturing only the texts that may come from the government-issued phone, but if there are any texts on personal phones that those, or personal email accounts, that those are captured as well, which is not a PCO function. It's a function of the witness.
In the measure that the government can have access to these communications.
The clerk suggests that to the measure the government could have access to these communications would be the right wording, but I mean, or alternatively, that we simply call for the production and we don't ask anybody specifically to produce them.
That would be fine.
I think we all understand the concept, and we'll get to the right words in the event that concept is accepted. I think that's basic there, that we're asking, that the motion is to ask for the production of these text, emails, communications related to SNC-Lavalin between the people mentioned, regardless of whether the device was government or personal.
Yes, thank you.
Thank you. Sorry, so Ms. Wright, did you wish to speak to your motion, or do you want me to pass it to the next person?
We can pass to the next person. I think it's evident and clear why we'd like to have paper copies of what's been disclosed.
Thank you very much. Mr. Boissonneau.
Mr. Chair, I think we.
Can I say one thing to Ms. Wright, which may be helpful, Mr. Chair?
Of course, Mr. Butts.
What I can tell you is that all of the information that I have at my disposal about that involve direct correspondence with the former minister about that December 5th meeting, I read entirely into the record. There's not something that I have not. Actually, that's not true. There is one thing, and it's a small personal thing, and it is that Ms. Wilson-Raybould was going to meet someone after our dinner, and she disclosed that to me, and I'm not sure it's appropriate for me to do that, to say. Okay, but
Perfect.
The entirety of the text that I have about the December 5th meeting with Minister Wilson-Raybould are quoted in my long statement.
Thank you. Thank you. So back to Mr. Boissonneau on the motion.
So, Mr. Chair, based on what Mr. Butts has just said, and based on where we ended up in the testimony with Ms. Raybould, I will be voting against Ms. Wright's motion. Mr. Butts has indicated that he has read the text into the record, and I think that is appropriate for the purposes of this study.
Okay. Further discussion?
I'll just request a recording.
Sure. Certainly, Mr. Barrett. So is there any other, but before we do that, I just want to make sure that there's nobody else that has their hand up.
I just want to say something. So the intent and purpose of ensuring that we capture any texts, emails between the witness and the Prime Minister's office staff is because I'm going through right now a chronology where two members of the PMO, according to Jody Wilson-Raybould, were very inappropriate in the way in which they approached her office as the Attorney General. And the witness has indicated that he has no knowledge of it, but that he believes in their sterling reputation, that they would not engage. He is their boss. I would like to see whether or not there are any texts associated with them reporting to him or him giving them direction. I think that is an absolutely reasonable request to be made.
Thank you very much, Ms. Wright. Any other intervention? Not seeing any. Mr. Barrett has requested a recorded vote. Mr. Barrett? I'm sorry, Mr. Barrett. Mr. Clerk?
If I may
Yep.
I request you to clarify with the committee there is an invitation today?
It's in. This motion is in order, I believe, for production. It is not an invitation to produce, right? And Ms. Wright, I'll look to you, but I believe that what you intend is that these be produced. Okay. So everybody understands this would be in order to produce these various documents between the individuals listed related to the SNC-Lavalin prosecution. Again, and Mr. Barrett has requested a recorded vote. I'm going to the clerk.
Merci, Monsieur le Président. Alors, Monsieur Boisson.
Thank you, Chair.
Mr. Essasi.
No.
Mr. Fraser. No. Ms. Khalid.
No.
Mr. McKinnon. No. Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Ms. Wright.
Yes.
And Mr. Rankin.
Yes.
In favor 4, en défaveur 5.
Okay. Donc la proposition a été faite, but
So the motion was defeated.
time is now up. You have 3 minutes on this round, sir.
I'd like to ask Mr. Angus to ask questions.
I'm
on
sorry,
our behalf.
Mr. Angus. Mr. Angus, the floor is yours, sir.
Chair, the question that's been put forward to us by the evidence of Ms. Wilson-Raybould is a concerted campaign of interference in the independence of the Public Prosecution Service by your office. That's the question before us. So her testimony provides us a picture. We have Mr. Marquez and Mr. Bouchard wanting an informal reach out to the prosecutor to go around her. She said that that would be political interference. Ben Chin says it's about the Quebec election, which would be a completely inappropriate thing for someone from your office to say. Bill Morneau, after being lobbied, pushed her and she told him to back off. The clerk of the Privy Council had numerous conversations one of which she said she was threatened 3 times, including where he said, "You don't want to be on the wrong side of this Prime Minister." The Prime Minister said, according to her testimony, that he wanted action because he was the MP for Papineau. Katie Telford, according to Ms. Wilson-Raybould, said she wasn't interested in legalities, and she has you on the record as saying, "I don't like the law, it's a Harper law," and then further, that we don't get through this without intervention. So how do you then tell us this was he said, she said, and not a concerted campaign that you were involved in to intervene and override the decisions being taken by the Attorney General of Canada?
Well, excuse me, I think I detailed the reasons why I don't think that was the case. I was present in the office for that time period described, and absolutely no effort to intervene in the independence of the justice system.
But you said to Jess Prince that we don't get through this without interference.
No, I did not say that, and I
So
explained
are
it.
you saying then that Ms. Wilson-Raybould testified? She was very believable to Canadians. You did not agree to go under oath. So the question is she wrong? Did she make that up?
I think I explained at length, Mr. Angus, what I think happened.
No, but I'm not getting an answer here. You may have explained it, but I don't understand. Because,
Mr. Angus,
as you say, with respect, she either lied or she
Angus,
didn't.
please let the witness finish.
Sorry,
Please let him just finish the answer, and then we'll come back to you. Finish the answer, Mr. Butts.
Mr. Angus.
It's about her credibility.
It is about what happened.
Okay.
And there are different perspectives on what happened.
I see.
I am not here to call anybody names, and you will not get me to cast
I'm not asking you
aspersions.
to call someone names. I'm asking whether or not there was interference, because facts, my friend,
is
as
the
you
answer
said,
to that question.
facts are
No is the
very
answer.
stubborn, because I will ask you then, it's not just her, but Ms. Philpott said, "I have lost confidence. I must abide by my ethical and constitutional obligations because of the allegations of interference by your office. There can be a cost to acting on one's principles, but there is a greater cost in abandoning them." So is Ms. Philpott not understanding this either?
I would certainly agree with the last statement that there is a cost to abiding by one's principles, as is there a cost to abandoning them.
Thank you.
I think that in this case, as I detailed at length, there's more than one way of looking at it.
Thank you very much. That ends the second round. I just would note that the witness did not refuse to be sworn in. The committee voted against swearing him in, as we have voted against swearing in any other witness on these meetings. So now we're at the third round. The third round is 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals, and then we have agreed that at the end of this round, the 3 other representatives of not recognized political parties in the House of Commons, because you need 12 seats, will be allowed to ask 3 minutes of questions each. So we will start with the Conservatives. Monsieur Berthold? Monsieur Berthold.
Mr. Berthold, thank you very much, Chair, and Mr. Butts. In your testimony, you've very clearly said that his departure from the Department of Justice, that this had nothing to do with SNC-Lavalin. Mr. Chair, I'd like to ask the witness, why did the Quebec government receive an indication on several occasions, even in Gatineau at the end of January, roughly 15 days after the cabinet shuffle, that the whole SNC-Lavalin affair was solved and that there would be a DPA? How can the Quebec government believe that such an agreement was already arranged if everything you wanted to do when you made repeated communications with the former Attorney General was to put pressure on her to obtain outside counsel? How could you suggest to another level of government that this agreement was already a done deal? How could the new Attorney General make the right decision? This doesn't fit with your testimony, because after a cabinet shuffle, well, now we have a minister, and we suggest to another government that there would be a deal. This doesn't really fit with what you said from the beginning.
I'm not aware of the situation you're describing. I'm not aware of any communications between the Government of Canada and the Government of Quebec on this issue. Certainly not in the time frame you're talking about. Well, that's not true. I'm aware of the fact that the Premier of Quebec, the current Premier of Quebec, raised it personally with the Prime Minister, as did the former Premier of Quebec, but I'm certainly not aware of what you're talking about.
Donc, vous n'êtes pas au courant
So you're not aware of any communication that could have happened between members of the cabinet or members of your office at that time with members of the Quebec government suggesting that SNC-Lavalin, thanks to the cabinet shuffle, would have a remediation agreement and such an agreement would be a done deal.
Merci beaucoup, M. Butts. Je laisse maintenant la parole à M. Cooper.
Great. Thank you, Mr. Chair, and thank you, Mr. Butts. You indicated that you know Mr. Bouchard and Mr. Marquez well. Would it be fair to say you spoke with them every day?
No. Well, I would say 4 of the weeks in question here that you're examining, I was in Washington. So not every day, no. Certainly not in the affected time period.
But they were briefing you?
From time to time on a wide variety of matters, yes.
And so you would have been aware of their activities on the file in general terms?
In general, yes. I mean, I certainly gave them overall direction, and they would report back from time to time.
Okay. And you mentioned that you were briefed by Prime Minister immediately after the September 17th meeting?
Sorry, I didn't hear that.
At the meeting with Ms. Wilson-Raybould, the clerk, and the Prime Minister, I thought I heard you say you were briefed immediately after that meeting on the 17th.
I did not say immediately after, and to be honest,
Okay,
I don't recall whether the clerk or the Prime Minister debriefed me on the meeting.
The Prime Minister asked for an outside opinion at that meeting?
Not that I know of.
Not that you know of. But we do know that on October 18th, Mr. Bouchard asked for an outside opinion to Jody Wilson-Raybould's Chief of Staff. The answer was no. On October 26th, again, Mr. Bouchard asked for an outside opinion to Jody Wilson-Raybould's Chief of Staff. The answer was no. On November 22nd, Jody Wilson-Raybould was called by the PMO to meet with Mr. Marquez and Mr. Bouchard, where again the issue of an outside opinion was raised. Again, Ms. Wilson-Raybould said no. And then on December 18th, you, at the meeting with Ms. Prince, in conjunction with Ms. Telford, again, were asking for an outside opinion several months later. Mm-hmm. What possibly could you have understood her answer to be other than no, and that therefore she had made her decision? She was not going to overturn the decision of Director of Public Prosecution.
So those are 2 different questions, whether she would accept external advice and whether she would overturn the decision of the DPP. And in fact, the distance between those 2 things, Mr. Cooper, I believe, is the heart of the matter at hand. My perspective on this, and it was informed by professional public service advice, was that there was nothing wrong with discussing this. And as I said in my testimony, I was not pressing in any way, shape, or form that anyone overturn the decision. And I think it's really, really important that we establish that as a fact. And it is...
No, but you were basically...
Please let me finish, sir, with respect.
Yes.
And it's an important fact because it is one of the few facts that seem to be shared. The minister testified that last week, and that was certainly my understanding. What I said in my statement about the meeting with Ms. Prince was that I sought to understand the minister's reticence on that file, on the concept of receiving independent advice, and made the case for doing so as a matter of sound public policy.
In other words, there was not a respect for her judgment to review the facts and review the law in the exercise of her prosecutorial discretion to overturn a decision that had already been made by the DPP, having regard for the facts and having regard for the law.
Could you just note that's last question? I'll let the witness respond.
Sure, and I'm happy to respond, Mr. Chair. And I should have said this more vividly at the outset, but I appreciate the opportunity to come here and speak with colleagues. I think it's an important matter you're discussing, and I hope that the evidence that I've provided can aid in your deliberations. At the end of the day, we really didn't feel that anybody was doing anything wrong, and that these were honest discussions. And I would ask you to deliberate on the question. If this was wrong, and wrong in the way it is alleged to have been wrong, why are we having this discussion now and not in the middle of September or October or November or December?
Much. We're now going to go to Mr. Assassi. Mr. Assassi, you have 6 minutes.
Thank you, Mr. Chair, and thank you, Mr. Butts, for appearing before a committee. It's been very helpful, especially your opening comments. Now, in your remarks, you delved into at length the decisions that animated the changes in cabinet. And my question for you
Which I'm sure will make me a lot of friends, but I was under obligations to do so.
Absolutely. Now, my preliminary question is, you were saying in your opening remarks that the first time SNC and the issue of deferred prosecutions came up was by Minister Philpott. Is that correct?
In the context of the cabinet shuffle, yes.
Yes. So prior to that, before you had reached out to any of the new people being appointed, there was no discussion whatsoever about deferred prosecutions or SNC?
Certainly not that I recall. I mean,
Thank you. Now, my second question is, when the Prime Minister spoke to Ms. Wilson-Raybould and advised her of changes to Cabinet, was there any suggestion at that point that she did not have confidence in the Prime Minister?
No.
Third preliminary question. Before Ms. Wilson-Raybould resigned from Cabinet...
You mean on that day in the debrief?
On the day that the Prime Minister
Right,
actually
yes.
called her to inform
Correct.
her
Yeah.
of her new position, there was no suggestion that she had no confidence in the
No.
Prime Minister. Before Ms. Wilson-Raybould resigned from Cabinet, did she ever suggest to you that she did not have confidence in the Prime Minister?
No.
Thank you. Now, if we could go back to the issue of obtaining a legal opinion or perhaps retaining an expert. During the period that you served in the Prime Minister's office for 3 years, were there other instances in which new legislation or a new legal regime was being considered or contemplated in which the Prime Minister's office decided to obtain a legal opinion?
I'm sure there were. It's a pretty standard operating procedure in my view.
I would think so.
Yeah.
Now, you said the first you heard about the need to obtain outside legal counsel was that was one of the recommendations that was made by the Department of Justice.
I'm not sure I would. It's been a long time since I read that memo, Mr. Assassi, so I don't want to be categorical about this. I don't know if it was a recommendation or an option, or since we seem to be having a bit of a Jesuitical discussion about fine definitions, I don't want to say something that is incorrect.
So would you mind telling us one more time why you thought it was a good idea to obtain outside legal expertise?
Sure. I thought that in a case like this, where so many people's livelihoods were at stake, that, and this was a shared view, it was an obligation of the government to make sure that we availed ourselves of every, that we took a really hard look at it, because you wanted to be able, when you go knock on your doors on the weekend, you wanted to be able to look employees of the company, pensioners, the supply chain in the eye and say, we gave this a good hard look. And that was all that was motivating us.
Absolutely. Now,
the people involved.
Thank you for that. Now, in your opening remarks, you also said that the first time you heard that the Attorney General had made up her mind on this issue on September 16th or 17th,
Yeah.
the first you heard this was last week during the course of her testimony.
That is correct. That is correct.
Now, given that you were not aware of that, would it be fair to say that your expectation was that she would consult with other departments?
Yeah, I think I want to be really careful here, Mr. Assassi, because, and I think Ms. Wright alluded to this earlier, I don't have any sense of what's in the Section 13 order, and nor should I. That would be inappropriate for me. But we thought broad consultation was really appropriate. Yeah.
Okay. And I take it you are familiar with open and accountable government?
I am indeed, yes. Pages 66 and 67, I believe,
Yes,
cover this
that's
subject.
right. So you've had an opportunity to read
Of course,
the various
yeah.
passages that would be relevant to this
Yes.
particular case. Now, the first passage actually says that it is appropriate for the Attorney General to consult with cabinet colleagues before exercising his or her powers under the DPP Act in respect of any criminal proceedings in order to fully assess the public policy considerations. What does that tell you, that particular passage?
It tells me, frankly, that nothing inappropriate happened here.
Okay. There's another passage on the same page. It says interdepartmental consultation is also important because of the shared responsibilities among government departments. Is it your opinion that the DPP regime or the SNC-Lavalin file is one that would require interdepartmental consultation?
No question about it.
Thank you.
Mr. Rankin.
You just said to Mr. Assassi that the first time you'd heard about her decision being final was last week. I think I heard
That's correct.
that
I said
correctly.
that in my opening statement.
So in her testimony, she refers Ms. Wilson-Raybould to a November 22nd meeting with Mr. Elder Marquez and Mr. Bouchard, and she said in her testimony that she took them through the Director of Public Prosecutions Act, prosecutorial independence was a constitutional principle, etc., and they continued to plead their case that we could hire an eminent person. They were kicking the tires. I said no. My mind had been made up and they needed to stop. Enough. So I gather that Elder Marquez and Mr. Bouchard work for you?
They work for the Prime Minister.
For the Prime Minister's
ultimately.
office of which you are the director?
And yes, myself.
Their
and Katie
report is
Telford.
to you, and so they knew, at least, it seems, if her account is to be believed. She said, I'll briefly pause about my state of mind. Final decision had been made, and so forth. In my view, the communications and efforts to change my mind on this matter should have stopped. Various officials also urged me to take partisan political considerations into account, which was clearly improper for me to do so. We either have a system based on the rule of law, the independence of the prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. So she said very clearly to your staff that this was to be the final decision. Mr. Butts, what we're here to do, this is to determine whether a line was crossed, whether there was independent, whether the line we must preserve between an independent Attorney General's function and appropriate considerations of relevant public policy factors was crossed. It seems clear from her testimony that subjectively she felt inappropriate pressure. Whether that's true or false or right or wrong, there's no doubt that's how she subjectively felt. But objectively, given all of the interventions, all the times she said no, the fact that there was no new evidence to be brought forward, the hounding that she claimed existed, how can we but conclude that that line was crossed?
Well, I think that 20 points of contact over 4 months is not a lot of contact, Mr. Rankin. And I think that if she felt at the time that the line had been crossed, then she should have been She had lots of opportunities at her disposal to
so
make
telling
that
it-
clear and put it on the
So
record.
telling it to your senior officials wasn't enough. It had to be someone else she had to go to.
I'm not going to comment on what happened in a meeting I wasn't present for, Mr.
Right.
Rankin.
So
but
that's
I,
what- that's
but
of
I,
course
but I,
what-
but I do believe, as I said in my statement, that if something this wrong had happened, that she had an obligation to at least inform the Prime Minister in writing. Yes, I believe that to be true.
Mr. Angus will use the rest of our time.
Thank you. I just want to follow up on what my colleague started, because on September 21st, she stated that this decision was no longer hers because the issue had been filed in court. It was no longer possible. You tell us you just became aware that her mind was made up last week. I find that surprising. November 22nd, the PM asked Mr. Bouchard to meet. She told him they needed to stop, and yet you're just now aware of this. December 5th, she says that she met with you at the Chateau Laurier and that Jerry took over the conversation and said, we need a solution. He said, I needed to find a solution. That's where she said that you didn't like the law because it was a Harper law. Then December 7th, she receives a letter from the PM and says that this is before the court. Then December 18th, there's an urgent meeting where they said, you said there was no solution that does not involve interference, and Katie Telford says, I don't want to debate legalities. And then December 19th, Mr. Wernick pressured her to speak to the prosecutor, and she said at that point she was waiting for the other shoe to drop, and the other shoe did drop. She was let go, and she's asked you when she was being let go whether or not this had to do with SNC, and you had asked her if this was questioning the integrity of the Prime Minister. How is it possible that you could run an office with that many people pressuring the Attorney General, and now you're surprised and didn't know what was all going on around you? How can you be credible to us when Ms. Wilson-Raybould gave us such clear, consistent testimony of a pattern of interference in an independent prosecution?
That is not my testimony. My testimony is that, as I said at the outset, I have a very different version of events. And I will say, I am not going to cast aspersions on a former colleague. I think that I tried to explain.
But just in all fairness, I just want this on the record. But I have a right to ask because
Mr. Mangus, your preamble was a minute and a half. I'm just going to let the witness finish the answer. Mr. Angus.
Did she tell the truth? Yes or no? That is the question. Not whether you're trying to be mean to her. That is not the question. If she told us the truth, then your testimony and the testimony and the credibility of the Prime Minister's office is in question. That is the question today.
I believe that everything I have said to this committee today is the truth. And I believe I described the events as they happened.
Thank you very much. We'll move back to Mr. Asasi. Mr. Asasi, you have 6 minutes.
Thank you, Mr. Chair. Now, I'd be remiss if I didn't point out to a third passage on page 67 of Open and Accountable Government. The third passage reads, formal consultation may also be warranted in cases that are of significant public interest, which raises legal issues of national importance, or which involve certain specialized areas of law. Do you think in this particular instance, it would have required that the Attorney General consult perhaps with the Department of Finance?
That sounds like you're asking me to do a technical evaluation based on the meaning of the law, but I think a common sense approach to this is that you take all of the input from your colleagues, and if you think that that input is appropriate, you tell them it's inappropriate. And if it gets to the point where you think it's as inappropriate as the former minister clearly now thinks it was, then you should inform the public at the time.
Thank you for that. Now, we heard from Ms. Wilson-Raybould during her testimony that she first received a notice from DPP regarding SNC on September 4th while in Australia, that she returned to Canada 8 days later on September 12th, and that by September 16th, she had made up her mind. Mm-hmm. In your opinion, would that have provided her enough time to do her due diligence, to consult with various departments?
Well, I think I covered that in my testimony, Mr. Sassy. I think it's a challenging explanation for the people whose jobs were at stake.
Absolutely. And you were explaining it to us today that your understanding is that when the public prosecutor is considering a particular file, that any time new evidence comes to light, that there should be a consideration of the matter, that one has to look at it with fresh eyes?
That's correct. That's my understanding. It's also my understanding that it's not possible to come to a final decision until the court process plays out and a verdict is rendered.
So are you concerned that she made her final decision before she actually consulted with the Prime Minister?
I think I have a lot of concerns about this, but I'm not sure I would agree with that characterization. I just think that I think that it was incumbent upon the people who were trying to put advice and evidence in front of the Attorney General to do so, and I think it was incumbent upon her to hear it.
And now, perhaps I shouldn't ask you what your expectations would be of others. Perhaps I should turn to how you look at this particular issue. And I'd like to ask you, do you have any regrets as to how this issue was handled?
Well, I like to look forward in life, Mr. Sassy, but we're all human. We all make mistakes all the time, and part of improving your professional life and your personal relationships is to examine the mistakes. On this case, I've looked at it really closely over the last couple of weeks, and I firmly believe that nothing inappropriate occurred here, and nothing inappropriate was alleged to have occurred until after the cabinet shuffle. Yeah, I mean, more broadly, there are other issues, but there are probably places and times and forums for that.
And in your opening statement, you mentioned you corresponded with Ms. Wilson-Raybould regularly. You expressed deep concern by what the minister was saying during some of those.
You mean post-cabinet shuffle?
Yeah. Yes, correct. You've expressed concern about that. Can you share with us today what the minister said and how that led you to determine there was a breakdown in communications?
Yeah, I think that part of her characterization of those conversations, and there were at least 4 or 5 of them, and they were long and they were personal, and they reflected 2 people trying to deal with a very difficult issue. There was a point where the minister asked me directly if her departure from the Ministry of Justice and Attorney General had anything whatsoever to do with the SNC-Lavalin matter, and I said no. And I did say, I asked her in a surprised tone whether she was questioning the integrity of the Prime Minister. It wasn't an accusation, it wasn't a threat, it was genuine surprise that someone that I had spent so much time with and that the Prime Minister had spent so much time with could interpret the request being the move in such a dark light, to be honest.
And lastly, you do indicate that the Prime Minister did offer her the portfolio of Indigenous services.
That's correct.
Why was that important to the Prime Minister, and what did he have in mind when he offered her that portfolio?
Well, very similar, as it turns out, to as everyone in this committee knows, the Splitting Vine Act was a Royal Commission recommendation, and when the Prime Minister, through the cabinet shuffle in 2017, I believe in the summer, I could be wrong about that, created the new Indigenous services portfolio, he made a really strong point, I felt at the time, of appointing Minister Philpott to that portfolio. She was obviously in her dream job in health, And she took on that role because we had a collective understanding, as you folks know around the government, about how important the reconciliation agenda is. And we wanted to make a very strong statement. The Prime Minister wanted to make a very strong statement that the agenda was not going to slow down, which is why he wanted to appoint Minister Wilson-Raybould to the role.
We now have Ms. May, Mr. Plamondon, and Mr. Weir each for 3 minutes, and then Mr. Rankin is advised he wants to make a motion, but perhaps we can do that after we excuse the witness. So, Mr. May, Ms. May.
Thanks. And I'm going to disclose that I'm friends with the witness, and I would be okay with the first name basis. So, it's okay with you, Chair.
It is.
I am surprised that in your evidence you don't make reference to two people that I think played a very big role in this drama, the clerk of the Privy Council and the lawyer for SNC-Lavalin. So I'm going to ask how it is that you don't seem to recognize that the heaviest intimidation of our former Attorney General came from one-on-one meetings with the clerk of Privy Council September 19th, and that with that following phone call December 19th, and I will let you know, I completely believe every word we heard from Jody Wilson-Raybould, without a doubt. So how is it that your evidence doesn't make reference to his actions, and did you know that he was going to phone her at home on December 19th and make veiled threats?
No, I'm aware that the clerk and the Deputy Minister of Justice are appearing later, so I know you'll have an opportunity to speak to them directly, but I will say about the clerk of the Privy Council, whom I've gotten to know fairly well over the past 3.5 years, that I find the accusations leveled against him completely inconsistent with his character. He has made enormous family and personal sacrifices to continue to serve the people of Canada. And I just can't imagine a circumstance where Michael Wernick would do the things he is alleged to have done. I find that even less credible given the fact that I am alleged to have done things I know I didn't do.
Well, I would only say, Jerry, that I still think that your evidence can be consistent with Jody Wilson-Raybould's, the extent that you were massively distracted by other events, out of town for 4 weeks, and could have forgotten things. But I don't find contradictions to the extent of he said, she said. But I'll move on to Frank Iacobucci, who is described in the one-on-one meeting that the former Attorney General had with the clerk as not a shrinking violet. Now, in the same period of time where there's a lot of pressure from SNC-Lavalin, Mr. Iacobucci, of course, is a distinguished former Supreme Court judge, was retained by the Prime Minister's office to handle the Indigenous consultations on the Kinder Morgan matter. Did that lead to you having conversations with SNC-Lavalin's lawyer on the subject of these threats that they might leave the country?
No, I've never had a conversation with Justice Iacobucci on SNC-Lavalin.
Can I ask then, did you seek independent evidence of any evidence that there was a threat to jobs? This is all riding on the threat to jobs, but based on the 2018 audited financial statements of SNC-Lavalin, they currently have $15 billion in back orders. They have a very secure financial situation with gross revenues of $10 billion. Is there any evidence that jobs were actually at stake by letting this go through the courts and letting the independent Director of Public Prosecutions do her job and the Attorney General also do her job?
Well, that's too bad. That's my understanding from Department of Finance briefings, but I have to say it's been a long time, and yeah, I can't recall anything specific. Liz?
Merci. On va passer maintenant à Monsieur Plamondon.
Thank you. Now we're going to move to Mr. Plamondon. The floor is yours.
To be clear, I can't recall, I cannot cite a specific study being done on a specific day by a specific person. I was briefed multiple times on that.
Thank you very much for that clarification. Monsieur Plamondon?
Mr. Plamondon, I appreciate the interpretation that we have here at the House. Well, if I understand correctly, on what precise date, since the decision had been made at the beginning of September, on September 16th, the minister decided at that time to not use the DPA. So at what time did you have the certitude at the Prime Minister's office that she would not change her mind, that she had made her decision? When were you informed that she had made her decision to not use the remediation agreement and to move to prosecution? At what date?
Thank you for your question. I think it's a central contention of my testimony that it was not possible for her to come to, for the Attorney General to come to a final decision before a verdict is rendered. So I was never aware until last week in her testimony that she believed that she had made a final decision on the 16th of September.
Okay. And when she did raise the question on December 5th, at your supper, was she the one who brought up the issue, or was it you? It was her who brought up the issue? Yes, correct. And even at that time, her final decision, in her mind, was already made since September.
I'm not sure how to explain that because as I said a few times, I don't believe it to be the case.
And under the law that was voted a year ago that allows these famous DPAs, did the two ministers who quit vote in favor of this law?
I'm not sure. I'm not sure.
And at the ministers' cabinet, did they discuss this legislation? Was it unanimous?
I believe, Mr. Chair, that's outside the scope of, because the matter went before cabinet last spring. Yeah, I can't comment on that.
One last question. On this bill, it allows the minister to intervene and to say, no, I'm going to reach an agreement rather than to prosecute the company. And up to when? Is it until the judge makes a decision, until that time, until a verdict is made, that she can intervene to ask for an agreement outside of court? Is that the case? Is it still possible at that time?
I believe that still to be the case. My understanding from the briefings I got at the time was that intervention was still possible until a verdict is rendered. And I think it's important to note about the concept of remediation agreements, where they came from in the first place. It was an attempt to we hear a lot about competitiveness around here, and it was an attempt to harmonize economic policy in Canada with many competing jurisdictions that already had this instrument at their disposal. There was a rigorous debate, as there always was on this topic, and there on most topics, and there were people on both sides of the policy. But at the end of the day, it was the collective decision of cabinet that it was a policy that was worth pursuing in the economic best interest of the country. And if I could say one more thing about DPAs, I think that they've been badly mischaracterized as a get-out-of-jail-free card, when what they really are is a court-approved reform process for a company that had committed very serious acts, and their purpose, and it's really important, their purpose is to protect people who had nothing to do with those acts from being harmed by the law.
Unfortunately, you had 4 minutes and 30 seconds. I'm sorry. Thank you.
Merci beaucoup. We're going to go to Mr. Weir. And Mr. Weir, by the way, I did check, and it was true that your question at our last meeting was the first CCF question at a committee meeting in 60 years of the Canadian Parliament. So it was quite historic. Mr. Weir?
Well, thank you for the opportunity once again, and thank you, Mr. Butts, for your articulate and informative testimony. To pick up on what you were just saying about deferred prosecution agreements, we heard last week from Ms. Wilson-Raybould that it was clear under the law that SNC-Lavalin was not eligible for a deferred prosecution agreement, and that therefore efforts to push that option were inappropriate. I think it's clear that you and many other people believed that SNC-Lavalin potentially was eligible for a deferred prosecution agreement. And I appreciate you're not a lawyer, I'm not either, but I'm wondering if you can shed any further light on the company's eligibility for that type of remedy.
I could not shed any light on that legal matter, Mr. Weir, I'm afraid.
Okay, it seems quite central to whatever misunderstanding or disagreement occurred.
Well, the centrality of it, though, with respect, I'm sorry, I didn't mean to interrupt you there. The centrality of it is that the law is really unclear because it was brand new. And in this circumstance, my understanding, as I said in my opening statement, is that this is the first case in which the law could be applied. So I think talking about these things as if they are matters of settled law, again, with the proviso that I'm not a lawyer, is a bit of a mischaracterization of the state of the policy, which is really fresh and never been applied. And we thought the more thought and advice and process that could go into this, the more transparency we could bring into the decision-making process, the better off we were all going to be going forward. It was we were plowing a new field here, and wanted to make sure that all of the lessons were learned and all of the wisdom was gathered and all of the advice was given.
So thanks for all the light that you've shed on the cabinet shuffle in January. With the benefit of hindsight, do you think that it was a mistake to move Ms. Wilson-Raybould?
I don't like to do retrospective recharacterizations of events. I think that the government was put in a very difficult position, and I think in particular the Prime Minister was put in a very difficult decision. I think that there was no malice toward anybody, and there certainly wasn't personal malice toward anybody. The Prime Minister made, I think, a well-informed decision about the cabinet shuffle, and had everybody on the team done what the Prime Minister asked of them, then I think we would not be having this conversation today.
Thank you very much.
Thank you.
Mr. Rankin, would you be okay if we excuse the witness before we move to the motion?
That's fine.
Okay, so Mr. Butts, of course.
Sorry, before I leave, that it was a real honor to be here. I appreciate very much the work that you do in all parties, and I hope that my evidence has contributed to a real public policy discussion. And I thank you all for your time and friendship. Thank you.
And in return, I want to thank you very much. I think your testimony was very helpful. Hearing your perspective was very helpful to our work. So thank you very much, Mr. Butts. And I'm just going to suspend for 1 minute so everybody can shake Mr. Butts' hand, and then we'll resume.
You are watching the conclusion of testimony from Gerald Butts, the Prime Minister's former Principal Secretary, before the Justice Committee. He has been testifying for about 2.5 hours following, he took questions from MPs on the committee. You can see them there all shaking his hand. He gave a pretty lengthy 30 to 40 minute opening statement in which I'll just go over the Coles notes, and I've got a power panel standing by to analyze what he said. But essentially his main argument was that nothing happened outside of the realm of normal government operations. So as expected, he's rebutting the claims by Jody Wilson-Raybould that she made before the Justice Committee last week that inappropriate pressure via himself or other people in the Prime Minister's office or even the Prime Minister himself was applied. And central to his argument seems to be the fact that he says that the decision Jody Wilson-Raybould took not to intervene in the SNC-Lavalin criminal case was never communicated in writing. And he seemed to not explicitly say, but insinuate that, and again, that's him leaving the room, the Justice Committee room right now, but seemed to insinuate that had it not been for the cabinet shuffle in January, the way in which Mr. Wilson-Raybould characterized that pressure as inappropriate, or those meetings that took place on this issue as inappropriate, would not have come to light. So as I mentioned, we've got the power panel here. I've got Chris Hall, Eric Grenier, Evan Dyer, and Marika Walsh of iPolitics in Toronto, all standing by to talk about what stood out for them. Again, about 2.5 hours of testimony and questions and answers of Gerald Butts in front of the Justice Committee. Chris, I'm going to start with you. What stood out to you?
Well, first of all, the tone. Jerry Butts made it clear from the very beginning he didn't want to get into a personal quarrel with Jody Wilson-Raybould. He thought that there was trust that had broken down, and we'll take him at his word on that. But there are a couple of things that he said that I think we really need to focus on. The first thing is that she never communicated in writing to the Prime Minister that she felt she was being pressured, or to him. She wrote everything down, we know. She's a copious note taker, and she put all these important decisions, he said, in writing. So that's one thing. And that calls into question her argument that the pressure was inappropriate, particularly after her final decision had been made sometime September, October, that the pressure or the contact continued. The contacts. He talks about 100 contacts a week over NAFTA, over TMX, 100 over the same type of period. He said 20 contacts on this file was not a lot, frankly, given how important the issue was. And he tried very hard to frame this in a public policy basis. Let's see if he's got something to say.
Let's listen in here.
2, 1, Steve. Okay. Brian, you got it? Yep. Okay, peeling right.
Sorry.
That's our Chris Rands, our producer Chris Rands.
Okay, watch the post.
I believe he's surrounded there by his wife and the lawyer for the Liberal Party, actually.
And lastly, the other really important issue was with respect to the legal opinion. We've heard a lot about whether she would be willing to get an expert outside analysis from a retired Supreme Court judge or a panel of eminent jurists. The answer was it was because this law was so new. We did not understand necessarily at the time what the ramifications would be. We wanted some opinion and advice about that. So those are the three things which now leave us in the position of taking what Jody Wilson-Raybould said last week and what I would argue from those 3 points that I just made are completely different views from him about what transpired and what the purpose of those meetings were.
Marika, let me bring you in here because this idea of the communication seems to be central to both what he was saying and why he characterized it as appropriate, the interactions, and what Jody Wilson-Raybould was saying when she characterized it as inappropriate. She says, and I was going through her testimony during his, on September 17th, she said she did explicitly tell the Prime Minister. In her words, she said, I told him that I had done my due diligence and made up my mind on SNC and that I was not going to interfere with the decision of the DPP. She later references meetings in which it was communicated to other staffers, I think in November, of the PMO. But Jerry Butts is right. So far, we haven't seen any of that communication in written form.
That's right, but I'm not sure that necessarily means that it didn't happen. And what's very interesting to me about Jerry Butts' testimony is that there's so much he could not speak to. So he couldn't, I believe he was asked if he was briefed on the meeting with the PM, and I think he said he didn't recall. He also says he doesn't recall her saying that the communication was inappropriate to him, and he can't speak to all these other cases where she told high-level people like the finance minister, like other senior staff in the PMO, and like the clerk that she had made a decision and that it was inappropriate. So I don't think it ties a bow on this issue, but it certainly, gives some context, as Chris said, about the meetings, about the number of meetings, and about what he says the goal was.
What do you think in the end, Evan? If you're somebody sitting at home and you've watched Jody Wilson-Raybould's testimony and now you've watched this, what do you think you can conclude, or can you?
You could say that there are areas where subjective interpretations of the same events, both truthful, could produce this difference between the two of them. But there's a few other areas where clearly, if one of them is telling the truth, the other one can't be. And one of those, I'd say, would be that meeting at the Chateau Laurier on December the 5th. So I don't think that Jody Wilson-Raybould in her original testimony, and I may be corrected about this, I don't know, but I don't think she said how that meeting came about. She discussed what happened in it, but I don't
And there's Jerry Butts leaving the committee, sorry to interrupt you, right now and heading out.
I don't think she said specifically that Jerry Butts had called her to that meeting, but I think
she
a lot of
said we had both sought out the meeting.
Both sought out the meeting, there you go. I think that he gave a different version of events in which it was clearly her who solicited the meeting. And then he was able to produce some text messages that certainly seemed to back up his version of events. So it would be difficult to have the same degree of certainty about what was said in the meeting. That's always going to be just a case of he said, she said, and nobody has, text messages to back up the content of the meeting. But the fact that he seems to be able to show that it was her soliciting that meeting and not him, you have to say that does undermine the suggestion that he was seeking to pressure her. If he was seeking to pressure her, surely he would have called on her to come to that meeting and not the other way around. So
I'll read you some of how she described that. She said, towards the end of the meeting, I raised how I needed everyone to stop talking to me about SNC as I had made up my mind and the engagements were inappropriate. Jerry then took over the conversation and said how we need a solution on the SNC stuff. He said I needed to find a solution. I said no and referenced the PI and JR. I said further that I gave the clerk the only appropriate solution that could have happened, and that was the letter idea, but that was not taken up. So the interesting part of her interpretation of that is also that word solution, because that came up a lot during the testimony, Eric, as well today, in which he was asked, did you use that word? Because there's another meeting that occurred between him, Katie Telford, the Prime Minister's Chief of Staff, and Jessica Prince, who at the time was Jody Wilson-Raybould's Chief of Staff, in December, in which it was alleged that, again, that word solution was used. Like, we need to find a solution. And that goes to the idea that the characterization of inappropriate, right? And he said he didn't recall using that word. So again, a discrepancy between the two.
And yes, and also with the meeting with Jessica Prince, that it was her recollection of what had happened that she was passing along to Jody Wilson-Raybould, and that Gerald Butts was in that meeting, and he said that he didn't see it in the same way. And one of the other questions that I think we've had going into this that was answered, at least from his perspective, was about the cabinet shuffle, because one of the questions was why was Jody Wilson-Raybould shuffled out of Justice into Veterans Affairs. He gave a plausible description of what the reasoning would have been going into the considerations in Nova Scotia in terms of who could be in what role, how moving someone out of Indigenous, because they moving Jane Philpott out of Indigenous into Treasury Board, because that made sense to move her to Treasury Board, required another a hard hitter in Indigenous, someone with a lot of respect who could be credible on the file, and that they hadn't considered that she wouldn't want that position and that would want to stay in Justice. And the explanation he made about not wanting to set a precedent of giving in to a cabinet minister deciding whether they get to be shuffled within. Yeah. So it was a plausible description of why that chain of events might have happened. Of course, it is his explanation of that chain of events, but it does at least provide us an answer, or at least a plausible answer, as to why this whole thing got kicked off in the first place.
Interesting also, Chris, that he brought up that Jane Philpott, when the Prime Minister told Jane Philpott that she was moving, she actually raised the idea that Jody Wilson-Raybould wouldn't necessarily like to be moved, or would consider it a demotion, I think he described it as, to be moved to Indigenous services, and that she might think it had something to do with SNC. And he remarked in his testimony that that would have been the first clue, or the first time he had heard that that might be the case.
And it was something that he should have considered, that not just a demotion, but as Eric just said, that after a lifetime of opposing the Indian Act, that she would now be responsible for delivering services under that very piece of legislation. There are a couple of things here that I think we need to add to as well. The context here is that the first time this ever really came up, he believes that the cabinet shuffle was the reason that this whole issue around being pressured and being demoted and being moved, that was the only time that he had really heard about that. When that became an issue for her that she had not illuminated before. I'll go back to all of this. There were two things that Jerry Butts needed to do today. One is to defend his own reputation, which I think if people listen to this, he sounded like he had good notes, that he wasn't bearing malice, that there was really a rationale to what they were trying to do and why he felt this was not political interference, but a real question of public policy. The other is to try to convince Canadians, which is more difficult because we're speaking, and I'm sure be people watching, who still don't really understand who to believe, who's right. Our recollections, simple differences of recollections at the very basis of one of the most difficult political crises any government will face. I'm not sure we got an answer to that yet. We certainly, I don't think, have left this behind. There are now reasons to recall Jody Wilson-Raybould, to ask her about that cabinet shuffle, because she said she couldn't talk about it before. There's also Katie Telford and others who were involved, and we heard efforts to try to get them, their text messages from Lisa Raitt, to have those produced. we really haven't put this to bed, is what I'm trying to say.
Yeah, and Marika, it's so interesting because on that cabinet shuffle, I totally agree, Chris, that there are so many follow-up questions that you would want to ask. And specifically, I mean, Jody Wilson-Raybould said that she took the Prime Minister. You heard even Gerald Butts talk about how she explicitly asked, "Is this because of SNC?" And he said no. And then he asked her, "Are you questioning the integrity of the Prime Minister?" What happened between that point? We still really are not clear on why she ended up resigning, right? Because she said she took him and took Gerry Butts and the Prime Minister at their word at that point. So something obviously changed in between that period in order for her to actually resign. And we don't know if that's key to, figuring this out.
Yeah, and I think you're absolutely right. I think it does raise more questions. And I think in some ways his testimony and what he said, puts more pressure on the fact that we do need to have more information about what went on from the time she was shuffled to the time she resigned, because nobody has been able to explain what the tipping point was or what changed that she no longer had that confidence. So I think that's another key thing that needs to be addressed. I think Chris is right that Gerald Butts did, a decent job defending his record, especially in the tone he set. He was very careful in how he spoke, but he has not answered, I believe, the questions that Canadians have. And it doesn't seem that there will be an answer unless a whole lot more people are actually called to this committee and asked to testify.
Let's touch on the tone there. I want to play a clip from Gerry Butts' opening statement, and then, Evan, I'll bring you in to talk about the tone. Let's listen to that.
I am not here to quarrel with the former Attorney General or to say a single negative word about her personally. What I am here to do is to give evidence that what happened last fall is in fact very different from the version of events you heard last week. It is based on direct communications with the former Attorney General and her staff, contemporaneous notes I took in meetings I attended personally, and debriefs from people who attended meetings I did not.
He was careful with his words, Evan, and especially near the end there when we heard Charlie Angus from the NDP and Murray Rankin really try to put Jody Wilson-Raybould's testimony and characterization of what happened against his, and asked, I think even explicitly, are you saying she lied? And he would not go there.
No, that did feel like an attempt to goad him into leaving his own script, which is these are the events according to me, and attacking the events according to her, and perhaps even going so far as to suggest that she's being dishonest, and he just didn't want to be drawn there. But at the same time, when you take the totality of his testimony, one thing that comes through very clear is that he's suggesting that this is really sour grapes over the shuffle, because he repeatedly talked about how this did not come up until the time of the shuffle. And it's very hard, therefore, to interpret his testimony in any other way. He talked about how many opportunities, and not just opportunities, but an obligation she would have had to communicate earlier if she thought there was something wrong. And I think one of the key lines he had was, if this was wrong, why are we having this discussion now and not in September, not in October? He laid out the months one by one, pointing out that she did have this long opportunity to raise these issues, but it only came up at the time of the shuffle. And that's something I think that it's hard not to come away from his testimony thinking
okay,
that
I'm going to move. The committee has broken, so I'm going to move back there. Let's take a listen to Randy Boissonneau, who questioned Gerald Butts. He's a Liberal member on the committee from Alberta. Let's take a listen in.
For the council to come back and respond.
So let's start with today. We heard very compelling testimony by Mr. Butts that sheds light on a number of the conversations, a number of the issues at hand here, and very interesting testimony. And what our job is as a Justice Committee is to take in the perspectives from many different points of view, and that's what Canadians are asking us to do, and that's what we're doing. I think it's important to note that Ms. Wilson-Raybould had over 4 hours with our committee, and it's important for us to understand broad perspectives on that. Today we also heard about the really important conversations that took place between Mr. Butts and key people in this matter, and so we're looking forward to hearing from Mr. Wernick and Mr. Wine this afternoon.
But key parts of her testimony don't match what Mr. Butts said. Key parts. So Canadians are left not knowing whose version is of the truth. So if you have two competing versions, don't you think you owe it to Canadians to bring her back to clarify where the contradictions are.
I think what we heard clearly today was that there was not any inappropriate pressure applied to Ms. Wilson-Raybould by Mr. Butts or by anybody in the Prime Minister's office. That was clear. It was also clear that the conversations that took place were about seeking external advice, and that was a conversation that they had with the Attorney General. It was also clear that Ms. Wilson-Raybould asked for meetings to continue and asked for other meetings to continue to take place. And I think we also learned, and I was shocked to learn, that she said no to serving in cabinet in an issue that is very important, even vital to Canadians. That's what we heard today, and it's important for us to hear from Mr. Warnock and Mr. Drouin this afternoon. En français? Oui.
Pourquoi ne pas réinviter Mme Jody Wilson-Raybould pour faire la lumière sur justement ces contradictions?
Je pense qu'il faut commencer
What about
avec,
the contradictions between those two testimonies? Well, I think that it was interesting to hear from Mr. Butts today. He shed light on the timelines and the substance of the conversations. And obviously, Ms. Wilson-Raybould had more than 4 hours in front of the committee with a long opening statement. And I think it's important as the Justice Committee that we hear different perspectives, and we will continue to do that with the clerk and Ms. Drouin this afternoon.
What I believe is that we have many perspectives on the same issue, and our job as a Justice Committee is to listen to all the perspectives, demonstrate the facts, get to the bottom of this issue, and that's exactly what we're doing. That's why we'll keep doing that this afternoon.
They're telling two different stories.
Mais je pense que ce que nous croyons,
What we believe are facts, and as was clearly indicated today, there are different interpretations of those facts, and today we heard very significant testimony with respect to the meetings that took place, the discussions that took place with the PMO and Ms. Wilson-Raybould. And the idea was only to seek other opinions as to whether SNC should go to court or not. And I think it's also important to note that Ms. Wilson-Raybould refused the position as Minister of Indigenous Services, which I found quite shocking.
Be telling the truth. Who do you believe?
Canadians asked to get to the facts, to understand what was happening here. That's exactly what we've done with now more than 9 witnesses.
Who do you believe? Mr. Butts or Ms. Wilson-Raybould?
We're continuing to get information from Canadians. We will hear from Mr. Warnock and Mr. Drouin this evening. I encourage everybody to go and read Mr. Butts' testimony. It was very revealing. Merci. Thank you.
That is Liberal MP Randy Boissonnault, who sits on the Justice Committee that just heard for about 2.5 hours from Gerald Butts. We're standing by to hear what opposition MPs on the committee say to reporters as they leave it. We're also anticipating more testimony this afternoon from Michael Warnock, the clerk of the Privy Council, and Nathalie Drouin, who is the Deputy Minister. Okay, let's listen in. We've Deputy Minister for Justice, and this is Anthony Housefather, the chair of the committee. He's also a Liberal MP from Quebec.
I believe that all the testimony we've received thus far was impressive. I won't characterize them in any specific way, but they are important for our work. Will you consider asking Ms. Wilson-Raybould to testify again? I believe committee members said that a motion was already passed, whereby we will look at the next steps after today's testimony. So it's really up to the members to decide on that. Well, there are some clear contradictions in that testimony. Well, I am the chair, and all I can do is try and explain what the members did.
Why does Gerald Butts get the last word?
Well, we're hearing from 2 more witnesses today.
No, when it comes to Jody Wilson-Raybould.
Well, again, we're hearing from 2 more witnesses today, and then the motion that the committee adopted was that the committee would then meet to consider next steps. And that was the answer given by members. And as chairman, I can only say what the members have decided.
The members can do whatever they like. There is a meeting that will be called to talk about the next steps after today's witnesses have testified. Should Ms. Wilson-Raybould be heard again? Well, as chair of the committee, I cannot comment on issues before the committee.
Get a chance for her to clarify what she said.
Again, right now, we have called 3 witnesses for today. We're going to hear from them, and the committee has said that they will then next meet and discuss next steps. I'm just the chairman. I don't even vote. So we'll see what they decide.
Just not speaking as the chairman, as a Liberal member of Parliament, are you okay with the fact that Gerald Butts gets the last word and Ms. Wilson-Raybould only gets 1 chance to talk?
Again, this was Mr. Butts' first appearance before the committee as well. and we will see what the committee decides to do after today's witnesses. I am the chairman of the committee. I can't disassociate myself from that, and I am now speaking as chairman of the committee. That's what the committee has decided. Thanks.
And what about the future of Ms. Wilson-Raybould, your opinion as a member of Parliament? Well, in my opinion, well, right now I'm acting as chairman of the committee and I can't comment on that sort of thing. I believe that Ms. Philpott and Ms. Wilson-Raybould have great contributions to make to the Liberal Party, and I'm glad that they decided to remain in caucus.
Again, I am proud that a parliamentary committee is doing its job to allow Canadians to watch the testimony and determine for themselves what actually happened in this controversial event. Many people thought the committee wouldn't do this. Many people said the committee wouldn't call the principals. Many people thought the committee would descend into a different type of atmosphere. I think we heard very cogently from the witnesses, and Canadians will decide. And the committee.
Sorry, one more question on that. Can Canadians make an informed decision if they haven't heard the complete story because Ms. Wilson-Raybould hasn't been given an opportunity to reply?
So Ms. Wilson-Raybould was before the committee for over 3.5 hours last week, and again, the committee will decide after it hears from today's witnesses what it chooses to next do. I'm just the chairman; I can't vote, and with that, I see my colleagues are waiting to speak to you guys. So I bid you adieu, and let Ms. Raitt have the floor. Thanks.
That was the chair of the committee, Anthony Housefather, and here is Lisa Raitt, Conservative member.
I'll go here first, and then I'll go to you, Julie.
What should Canadians think?
Okay, Julie.
What should Canadians think about the fact that Ms. Wilson-Raybould's testimony, which was very different, will not be allowed to come back to clarify?
Well, I think Canadians are going to be pretty ticked off, to be honest. Mr. Butts today testified on points of time that Jody Wilson-Raybould said she could not testify on. And then when we put forth the motion, when Murray put forth the motion to have her come back and testify again, the Liberal members of the committee decided, well, we've heard enough. Nothing to see here. Nothing new can come of it. And I think that's atrocious. I think Canadians want to hear the entire story, especially given that Mr. Butts' entire testimony was completely opposite of what Jody Wilson-Raybould said, especially on when dealing with the staff of the Prime Minister's office. I mean, he said, I don't think those guys would do that. They have a sterling reputation. I can't imagine they would do that. And the same about the clerk of the Privy Council. I can't imagine he would do that. Well, luckily we have the clerk this afternoon to talk to, but we still need to hear from Jody Wilson-Raybould, because regardless of whether you believe her now or not believe her, the reality is there are stark contradictions, and one of them isn't telling the full story. And we need to find out which one it is. And the only way to do that is by bringing back Jody Wilson-Raybould and putting Mr. Butts' testimony to her, and let's see what she has.
Your party had said that she was a very credible witness.
Yeah.
Is that now in question?
No, not at all. She's a very credible witness, but the inference is that Jody Wilson-Raybould did not tell the truth to the committee last time. So yes, we'd like to hear back from her on the basis of the fact of there is two different stories, but on the off chance that she isn't telling the truth, then we should hear back from her even more so. You would think the Liberals would want to hear from her even more so, because it's clear that her testimony completely is in contradiction with Mr. Butts' testimony. So why would the Liberals not want her to come in and test her and say that she isn't telling the full truth? I know why, because they know that she is far more credible than Mr. Butts was in terms of the questions. You're very patient.
I was just going to ask, with Mr. Butts' testimony, is this just a simple misinterpretation of events, a difference of opinion? What did you take away from that?
He doesn't know all the events. He said quite clearly he did not know of any meetings that the PMO staff were having, pressuring, being inappropriate with Jody Wilson-Raybould. He even said that he didn't know she had made a final decision until he heard about it in her testimony last week. You got to take that with a grain of salt, because it would appear that a lot of his conversations with Jody Wilson-Raybould were very intense, and they were on these topics. So how it would never come up that she had made her final decision, she doesn't seem to me to be somebody who pulls her punches, and I would expect that she told him what she told him. And he said that he did not learn about her decision being final in her mind until she gave that testimony last week in front of Justice. I think that's a reason. En français, absolument. Oui.
First of all, what is your reaction to the idea that Ms. Wilson will not be able to testify again? I think that's completely unacceptable, given that we have two different versions of the events. Now, there were meetings with Ms. Wilson. There was communication between the PMO and the former Attorney General, and it's perfectly normal for Canadians to hear full testimony with no restrictions from Jody Wilson-Raybould, because we heard things from Mr. Butts this morning that were not subject to the same restrictions as Ms. Wilson, and I don't think that's right. I think Canadians deserve to hear the entire version, particularly if there are two different versions. There may be someone not telling the truth, and I think that we need to hear, it seems to me the Liberals should want to hear more from Ms. Wilson, but they just said no to a new appearance, and that's completely unacceptable. Canadians are entitled to the full truth, and unfortunately this morning all we heard was part of that, which didn't really contradict Ms. Wilson's testimony. So I think we really need to hear from her again. Now, Ms. Wilson-Raybould made very credible testimony with specific dates and with her notes, and I think she should have an opportunity to come and give her version of what Mr. Butts referred to today. Well, I think Ms. Wilson should come and give her version based on what we heard this morning, because we heard something very specific and clear from her with concrete evidence, and on the other hand, we only have certain perceptions of what the meeting was like. And we couldn't get all the information because the Liberals refused our motion to have access to all the emails. They're refusing to get Ms. Wilson back to testimony, so it's clear today that the Justice Committee will not have all the truth. Doesn't it surprise you she didn't take the time to analyze the situation before deciding that she would not interfere? Well, the fact is that the PMO got involved at that point, and it was political interference.
Began after the shuffle, that she didn't like what she was being shuffled to. What do you think he was implying, or what do you think Canadians should make of that?
Well, I think Jody Wilson-Raybould gave testimony on that already, and she said so long as she was sitting in the chair as the Attorney General, she knew that she could withstand the inappropriate entreaties that were given to her, and that if she saw the fact that it was gazetted, that a decision had been changed, that's when she would have to resign from Cabinet. That's her testimony. She felt that she did a better role as making sure that the rule of law was protected from the PMO as opposed to anything else, and that's why she opted to not move forward. I think the sour grapes defense that Mr. Butts put forward today is not cogent, because at the end of the day, the reality is Jody Wilson-Raybould made a decision that she was not going to tell the Director of Public Prosecutions to stop the criminal court proceedings. She stood by it. She withstood all the pressure. She agreed to take another position in Cabinet, but then she decided she was going to leave Cabinet because she no longer had confidence in what was happening there. We don't have testimony from her on that point because we can't get to it. That's why she needs to come back. We have the NDP behind. I'm not trying to cut it short, but we have a very short lunch break. We will be back. It's like that TV show. We will be back after commercial break, after the next testimony. Mr. Wernick, thank you for your patience.
That was Lisa Raitt, a Conservative who was questioning Gerald Butts on the Justice Committee earlier today. He testified for about 2.5 hours. I'm Vashi Kapelis. You're watching a special edition of Power and Politics. We're waiting word now from the NDP. Here's Jagmeet Singh, the leader of that party, to comment on what we've been listening to.
Well, today the testimony was clear, and we believe Ms. Wilson-Raybould's testimony. I don't believe Mr. Butts really answered or addressed the real issues. What he said was that there was no attempt to interfere, that there was no scandal, and that's why we think there is a need for a public inquiry to get down to the truth. Canadians need to know whether the government is working for them or whether the government is working for their friends in the Liberal Party.
What we heard today in no way addressed the scandal, in no way puts to rest the questions that Canadians have. Canadians believe Madam Wilson-Raybould for a reason. Her testimony was credible, was thoughtful, was detailed, precise. What we heard today from Mr. Butts in no way addresses the key questions. In no way his responses where he didn't know about the vital information. In no way does he actually satisfy the concerns that are raised. More than ever, in fact, points to the necessity of having a public inquiry. Canadians want to get to the bottom of what's going on. They need to know what's going on because Canadians believe the government should be working in their interests, and right now it looks like this Liberal Party, the Prime Minister and his office are working in the interests of the powerful and well-connected, not in Canadians' interests.
Wait, what do you mean it was incredible? What do you think he lied?
His evidence is simply defies all logic. The fact that he can come to this committee and say that there was nothing inappropriate at all, that he didn't know that Ms. Wilson-Raybould had taken a position, that is just ludicrous to suggest that. That is incredible testimony. When Ms. Wilson-Raybould repeatedly indicated to many people that she had made a decision, for Mr. Butts to come to this committee and say he just learned about that last week, just defies all logic. It is completely ludicrous and really erodes any credibility that his testimony has whatsoever.
He said it was important to get information when it's dealing with so many jobs and it's a new law, this whole remediation process. Why don't you think that's credible?
No, I'm saying that what's not credible is very clear. The fact that he says that he didn't know that Ms. Wilson-Raybould had taken a position, the fact that he says, I just learned about this recently, it was abundantly clear from Ms. Wilson-Raybould's testimony the numerous times she made it clear that the pressure was inappropriate, that she had indicated she had taken a position, that she repeated that she had taken a position multiple times. For Mr. Butts to come here and say that for some, to have us believe that he didn't know that she had taken a position, that her position was not clear, that she didn't put it in writing, really just lacks any sort of believability. Pas du tout. Ce qu'on a vu,
No, what we saw today was a total difference between the truth and an attempt to escape the truth. That was the contrast. Ms. Wilson's testimony was clear and detailed with specific details, and what Mr. Butts said, oh, I'm not aware of the details, I'm not aware of the conversations. I didn't know that Ms. Wilson had made a decision. That's completely unbelievable.
La date du 16 septembre était les bienvenues par Mme Wilson-Raybould et qu'elle voulait avoir des conseils, des avis. Donc, vous ne croyez pas là-dessus?
What
I don't believe is the fact that Mr. Butts said that nothing was inappropriate. Ms. Wilson-Raybould repeated several times that she mentioned and noted a few times that there was inappropriate pressure on her, that it was unacceptable pressure. She repeated that several times, and Mr. Butts' testimony did not address that allegation.
What do you make of the fact that Mr. Warnick gets a second opportunity to talk this afternoon, but Ms. Wilson-Raybould, her opportunity just got shut down by Liberal MPs?
Let's just talk about that for a moment. My colleague, Mr. Rankin, put forward a motion, and it's really important for us to highlight this. The majority Liberal committee voted against allowing Ms. Wilson-Raybould the opportunity to come back and rebut the testimony we just heard today. But Mr. Warnick is going to come back. That is a clear example of why this committee, though it's important for us to continue working, is not going to be sufficient to get to the truth. When they're not willing to have the key witness who has just been contradicted with really weak testimony by Mr. Butts, and when this committee has voted against allowing her to come back to committee and to provide her testimony again, shows very clearly that this is a biased process, that the committee is attempting to avoid getting to the heart of this matter. They're afraid of Ms. Wilson-Raybould coming back because she's going to prove everything that Mr. Butts said was wrong. And it just really points out that we need a public inquiry. Canadians want to get to the bottom of this. Canadians ought to know that their government's working on their side. And right now we're seeing again and again more attempts at a lack of transparency, attempts of covering up what actually happened, attempts to avoid having the key witness come back and provide more testimony to get to the heart of this matter. All of this speaks to this government's, the Liberal government's desire to not get to the truth, and that's why we need a public inquiry.
What do Canadians lose
I'm here
by not hearing from her again? What do Canadians lose?
Well, they lose out. They've just heard from Mr. Butts, who's put forward a number of points that Ms. Wilson-Raybould is the key person that can actually respond to. She is the person that can say, this testimony that was just provided is in no way consistent with what she's put forward. She's able to show her massive amount of details and facts and precision around dates, precision around text messages she received. She can refute many of the claims that were made today, and Canadians miss out on the opportunity of hearing her refute the effectively baseless and incredible testimony we just heard from Mr. Butts.
Do you think he was suggesting sour grapes?
Yes, he was, and he's undermining not only the fact that Ms. Wilson-Raybould took a principled position, he's undermining the fact that Ms. Philpott also resigned because she found that she had no longer any confidence in this government, the Liberal government, and in the Prime Minister's office, and in fact in the Prime Minister. And the fact that that is being attributed to sour grapes or attributed to friendship when it's a matter of principle. That's what it is, a matter of principle, and these two very credible folks took principled positions, and Mr. Butts is seeking to undermine their credibility and undermine their principled position with allegations that don't hold any water.
Monsieur Singh, selon le témoignage d'aujourd'hui, Jody Wilson-Raybould aurait pris sa décision très rapidement concernant l'accord de...
According to today's testimony, Ms. Wilson-Raybould made her decision very quickly not to intervene.
Sans consulter, par exemple,
Do you think that was appropriate? Well, she made a decision after almost 2 weeks. She made a decision with all the information, and Mr. Butts did not give any examples of new evidence. Every time that Mr. Rankin asked if there was new evidence, he said, I don't know. So that shows that he was trying to find a reason. But the truth is that there was no reason to continue to pressure Ms. Wilson-Raybould. There was no new evidence, and once again, this shows we need a public inquiry. Well, every time we asked questions, I mean, if there was new evidence, why did the person in charge of the PMO not ask what that new evidence was? If there was something new there, then that should have been discussed, but there's no reason to believe that there was actually any new evidence that should be reflected on. Ms. Wilson-Raybould's decision was clear and the pressure was inappropriate, and it's clear now that we need a public inquiry.
One thing, that struck me, I don't know if you noticed, but Madam Wilson-Raybould came to the committee and she said very carefully, I cannot talk about events after I was removed from my role as Attorney General. Mr. Butts, however, felt that he could. So we'll never know, if we don't have her back, just exactly what happened when she was removed from that position. We'll never know about some of the subsequent events that he felt totally comfortable talking about, but which we're not going to be able to hear about. That's why we have to have her back.
Why should we hear from Ms. Wilson-Raybould again, in your opinion? Ms. Wilson-Raybould is a key witness in this scandal, and she can answer to the allegations and address the testimony given today by Mr. Butts. Also, what happened after her resignation as Attorney General, all of that is still subject to the solicitor-client privilege, and therefore we don't know what actually happened after she resigned as Attorney General. We don't know what happened in Cabinet or any of that. These are things we haven't heard about, and that's why we need Ms. Wilson-Raybould to testify again.
Ms. Wilson-Raybould and Mr. Butts experienced together, or Mr. Butts said that it's a matter of interpretation. People can experience things differently. It sounds like you believe Ms. Wilson-Raybould. Why is that in these cases?
More importantly, Canadians believe Madam Wilson-Raybould. Canadians believe her because her evidence and testimony was very credible, very detailed, and very straightforward. What we saw today from Mr. Butts does not have those same hallmarks of credibility. He did not have the same details, and in fact, what he's suggesting is just so incredible. He's suggesting that at the level that he held, as high-ranking as he was, that he did not know that Madam Wilson-Raybould took a position until just recently last week. The fact that he makes that claim and that assertion just completely erodes any credibility that anyone listening to this testimony could possibly have in what Mr. Butts just said. It just defies logic and defies any sort of believability that Mr. Butts did not know. I mean, it's just so outlandish to suggest that. And what we heard from Ms. Wilson-Raybould was very credible, very consistent testimony that pointed out the numerous occasions where the pressure was inappropriate. And she had repeatedly said this pressure is inappropriate. Are you pressuring me now? Back down. This is not appropriate. She consistently said that, and given what we heard from Mr. Butts today, it just does not in any way align with what we heard from Ms. Wilson-Raybould.
So Mr. Angus, where does this leave Canadians?
Well, I think the Prime Minister has made a serious mistake today by not having his Liberal MPs invite Ms. Wilson-Raybould back, because the picture they're trying to portray to Canadians is, this sad mistake of, emotions, that maybe they just misunderstood each other. Well, Ms. Wilson-Raybould was clear. She was not misunderstanding. She named names, she named dates, she named moments when she said inappropriate pressure was being made, and Mr. Butts on all those key moments can't seem to remember, or he has a different interpretation. We have lost 2 top cabinet ministers from his government. The fact that the Prime Minister is refusing to call an independent inquiry, the fact that they're refusing to let Ms. Wilson-Raybould speak again is a pattern of this he said, she said one time, and then they go back to saying, well, it was just a matter of opinion. It is not a matter of opinion. It is a matter of whether or not this government interfered in a prosecution case and attempted to undermine the work of the Attorney General. That is the question, and we have not gotten that answer because they're not letting Ms. Wilson-Raybould come back.
20 communications in 4 months, is that really pressure?
Well, I think when you see that Ms. Wilson-Raybould said this was before the courts, the matter's closed. Then they said, well, there's a matter of an election. She said that that's inappropriate. And then they said, well, let's go around you and let's talk directly to the prosecutor. And she said, back off, that is inappropriate. We're talking about the independence of the prosecutor. Mr. Butts taking over the meeting. She said he took over the meeting and said, we need a solution. Are we to believe now he didn't know that she had made a decision? And then, of course, the most damning, we don't get out of this without some kind of interference in Ms. Telford saying, well, I'm not interested in legalities. This is about the rule of law. And if this was just he said, she said, we wouldn't have someone as credible and powerful as Ms. Philpott saying, out of her obligations to the Constitution, she's been forced to resign and she's lost confidence in this Prime Minister. I think the Prime Minister needs to come clean. Thank you.
Thank you. Thank you.
That was the leader of the NDP, Jagmeet Singh, Charlie Angus, and Murray Rankin, 2 other NDP MPs. They were commenting on the morning that we just saw. Gerald Butts, the Prime Minister's former principal secretary, testified before the committee for about 2.5 hours, said that nothing inappropriate happened. As expected, rebutted what we heard from Jody Wilson-Raybould last week. The crux of what we heard from opposition MPs and the questions towards actually Liberal members of the committee as well was around this motion that happened after Gerald Butts' testimony. I think Murray Rankin, the NDP member there, put that forward to recall Jody Wilson-Raybould to testify again before the committee to ask questions that have arisen as a result of Gerald Butts' testimony. Liberal members of that committee, it's our understanding, voted that motion down. Let's get a quick final round of comments from our power panel standing by. Chris, I'll start with you. So it looked like they're not ruling out forever hearing from Jody Wilson-Raybould again, but clearly they blocked the attempt today to go forward with that.
Yeah, and we don't have a real explanation for that. Anthony Housefather, who's the chair, saying the committee will meet afterwards to decide who to recall. Anybody who's been following us will know that Michael Wernick is now appearing for a second time. And given the discrepancies, different opinions, the different interpretations of the events that took place last fall between what Gerald Butts has said today and what Jody Wilson-Raybould testified to last week, would suggest that Canadians really don't have a chance to hear from her again about those discrepancies, why this might have been different. And in particular, I think the most important consideration here is that she never made, especially in writing, any concerns known to the Prime Minister or to Gerald Butts himself, and that only after she was shuffled out of her position as Justice Minister did the whole representation about the prosecution about SNC-Lavalin come up.
Right. Eric, what do you think?
Well, I think for Canadians watching it, it still comes down to a degree of interpretation of where the line is and whether it was crossed. And it's still, we have still 2 different views on this. And I think in the context of everything that happened with the shuffle and all that, it's certainly possible that both Jerry Butts would look back at the actions that he did and his office did and think that they were a lot softer than they ended up being, and also that Jody Wilson-Raybould, trying to explain why she shuffled out, would look back as well at these events and think and see that her role had been a lot firmer and her position a lot clearer than maybe it had been. So it still comes down to interpretation, both of what people are going to take as where the line was and whether it was crossed, and also both of these actors where they feel those lines were and where things might have been crossed or not.
Marika, given what we heard throughout the testimony today and then in the scrums following from opposition members and Liberal members of the committee, can the committee really get away with not calling Jody Wilson-Raybould back? Like, what are the optics of that, given that, as Chris pointed out, we're going to hear again from Michael Wernick, the clerk of the Privy Council this afternoon, and again from the Deputy Minister of the Justice Department, Nathalie Drouin?
Yeah, it's hard, if their argument is that everything is above board and this will be cleared up through this committee process, which is what they're saying, then it's hard to see how they don't then call her back to rebut or explain or give her version on Gerald Butts' version. The bigger problem for the Prime Minister's office right now is that Gerald Butts today has not, in any way put a lid on this. He has not closed the door on a few open questions. If anything, there's more questions. He's defended his own actions, and he has defended the character of some of the other people involved, but he has not really put a hard X or close the door on any of these big questions about whether she did or did not raise the question of inappropriateness. She says she did, I believe, from her testimony, about 4 times with different people. And he says, I don't remember. And that's exactly what Finance Minister Bill Morneau said, I don't remember. And I'm not sure that that's good enough for Canadians.
Well, it's interesting, Evan, and speaking about kind of closing the door, I mean, there are a lot of meetings that she references or conversations she references that actually don't involve Gerald Butts. So this is a portion, for sure, and Michael Wernick's testimony will also be a portion of those interactions. But like Bill Morneau, Ben Chin, his chief of staff, as well as Matthew Bouchard,
yes.
Mr.
Marquez, yes.
Mr. Marquez, Katie Telford, the list goes on. So
and there's a couple that don't involve JWR, at least one with
Jessica Prince, her former chief of staff. So it is hard to see how this kind of ends up unfolding, and you can't imagine it kind of ending anytime soon.
No, I mean, I think I would agree with everybody. I'd like to see Jody Wilson-Raybould come back and address these discrepancies too. I'd also like to see a more complete waiver that goes right up to the present day and lift the lid off everybody's ability to speak. But having said that, I guess one could get into an endless, will Jerry Butts then get a right of reply to her? We could go on and on and on with that. One thing that is important to point out is that there's nothing that prevents her from going up on a rooftop right now and shouting out to the world any problems that she has with what Jerry Butts...
Or coming on Power and Politics.
Or coming on,
today.
even better.
Yeah, even better.
And explaining exactly what issues she has with what Jerry Butts did say. I would say one thing also that, we did hear her testimony described by several opposition members as being well documented, but there are a couple of elements that were not well documented. One of them is in writing, any kind of communication of her decision being taken.
And that was Jerry Butts' point.
That was Jerry Butts' point. And the other one is anything in writing where she's raising concerns about undue pressure. We haven't seen those. And for a person who writes everything down, it would be it's interesting to at least ask why none of that is able to be documented. And I think he was at least able to raise a doubt about that.
I imagine that's part of the reason why everyone wants to hear from her again before the committee. So we'll see how that progresses. Thank you, everyone. Thanks for standing by and listening to all those hours of testimony and helping us understand it. Thanks very much to Marika Walsh, Evan Dyer, Eric Grenier, and Chris Hall. I'm Vashi Kapelos. Chris and I will actually be back at 2 o'clock in about 45 minutes to cover more testimony before the Justice Committee. We're about to hear from the Clerk of the Privy Council, as we mentioned, Michael Wernick. Once again, he testified before already, and Deputy Minister of Justice, Nathalie Drouin. So don't go anywhere. There's a lot more analysis coming up on CBC News Network with Andrew Nichols. Stay with us.
Of our